Joining the committee today is the Minister for Rural Affairs and the Natural Environment, Mary Goujon, and her officials. Welcome to you all. We're also joined by Colin Smith MSP and Maurice Golden MSP. Welcome to you too. We have a lot to get through this morning, so it will work well if we take it slow and steady. When I call you to speak, please take a short pause before speaking to allow your microphone to be switched on. So everyone should have a copy of the bill as introduced and a marshalled list of amendments which sets out the amendments in the order in which they will be disposed of, and you'll also have the groupings. So can I remind members that requests to speak should be made by typing R into the Blue Jeans chat function once I've called the relevant group, but please only speak when I call your name. Only committee members are eligible to vote, and voting will also take place using the Blue Jeans chat function. Once I've read out the result of the vote, should you consider that your vote has been incorrectly recorded, can you please let me know as soon as possible, and I will pause to provide time for this. And I also want to say from the outset that if we have tied votes on any amendments, I will, as convener, vote in the same way that I voted in the division, and I'll do that consistently throughout the whole process. Should time be against us this morning and we do not manage to complete our consideration of the amendments by 1 p.m, we'll continue consideration of the bill at our next meeting. If we lose connection to any member or to the Minister, I will suspend the meeting until we reconnect. And in the unlikely event that reconnecting is not possible, we will need to reschedule our stage 2 consideration. So I'm going to let you all know that I'm going to suspend for a 5-minute comfort break at suitable point this morning, probably around about 11 o'clock. I strongly encourage short, succinct contributions from all those speaking today, if that's at all possible. And I'll now begin stage 2 proceedings. Right. So I call Amendment 65 in the name of Colin Smith in a group on its own, and I refer members to the correction slip issued for this amendment. I ask Colin Smith to move and speak to Amendment 65.
Thank you very much, Convener, and good morning to the committee. Amendment 65 in my name, which I formally move, seeks to extend the scope of the 2006 Animal Health and Welfare Act, so it includes cephalopods and decapods as protected animals. That is, animals such as octopuses and squids and crabs and lobsters. These animals are not currently covered by this Act, meaning they do not receive any protection under it. The Scottish Government have previously indicated a willingness to consider such a change should appropriate scientific evidence become available. However, there is already significant evidence that these animals are sentient, intelligent and capable of experiencing pain. 2007, a paper on the cognitive ability and sentience of aquatic animals by Professor Donald Broom concluded, and I quote, "There is evidence from some species of fish, cephalopods and decapod crustaceans of substantial perceptual ability, pain and adrenal systems, emotional responses, long and short-term memory, complex cognition, individual differences, deception, tool use and social learning. The case protecting these animals would appear to be substantial. Cephalopods in particular are known to be incredibly intelligent. Octopuses have large, well-developed brains and have been found capable of learning, navigating mazes and solving puzzles. Similarly, decapod crustaceans have been found to be capable of experiencing pain, and animals such as lobsters have a very advanced central nervous systems. In fact, a 2005 paper by the European Food Safety Authority on the welfare of animals used for scientific purposes designated both cephalopods and decapods Category 1 animals, that is, animals where the scientific evidence clearly indicates that those groups of animals are able to experience pain and distress. The 2006 Act provides a specific exemption for anything which occurs in the normal course of fishing, so I want to stress this amendment would not have an adverse impact on the fisheries sector, while other sectors would simply be required to maintain the same standards of care as they do for all protected animals. Making them protected animals under the 2006 Act would reflect the evidence of sentience and ensure that they are protected from cruel treatment and inhumane methods of slaughter. They're protected by animal welfare legislation in a number of other countries. This change would simply bring Scotland in line with international best practice and reinforce our reputation as a world-leading country for animal welfare. If the Minister is not willing to support this amendment and is not convinced by what I believe is the clear evidence, I hope she will clarify what actually would be considered sufficient evidence to make the change. And I hope she will provide assurances that the Scottish Government will make the change as soon as the evidence that satisfies her emerges. Thank you, Convener.
Thank you. And we have one other member who's indicated that they want to speak on this amendment, and that's Mark Ruskell.
Colin Smith. I was on the predecessor committee which dealt with the 2006 Animal Welfare Act, and we had quite a lot of evidence coming forward at that time that there are species that don't have backbones, they're invertebrates, but nevertheless they can feel pain, distress, and show complex behavioural patterns. So I think what this amendment does is it brings us up to speed, it brings us in line with the European Union and UK legislation on scientific procedures, which recognises that decapods and cephalopods are sentient and need to be protected under animal welfare legislation. So I think it's a welcome catch-up. The evidence is there. We should be bringing these species into line with the protection that exists for other vertebrates.
Thank you. And I now call on the Minister.
Thank you, Convener. The purpose of this amendment, as has already been explained, is to expand the definition of animal in Section 16 of the 2006 Act. However, the 2006 Act allows for this type of change to be made under the regulations, and therefore that's why I wouldn't be supporting this amendment at this time. There will be a scientific review of the evidence for sentience in cephalopods and decapod crustaceans in the near future, and the outcome can then be considered by the UK Animal Welfare Committee and our new Scottish Animal Welfare Commission. So if that review of evidence illustrates that cephalopods and decapods require that protection under the Act, I would, of course, be happy to bring forward the necessary consultation and potential statutory instrument for consideration by the committee through the affirmative process. So, as a result, I wouldn't be supporting this amendment, and would ask Colin Smith, if he's happy on that basis, to withdraw it.
Thank you. I now call on Colin Smith to wind up and to press or withdraw the amendment.
Thank you, Convener. I do welcome the Government's willingness to consider the issue. So at this stage, I'm happy not to press the amendment on that basis. However, I would like to reiterate the point that I believe there is already sufficient evidence to merit an urgent review of the scope of the 2006 Act. I understand there is, as the Minister refers to, research currently being undertaken by DEFRA into the sentience of cephalopods and decapods, and I hope this research will confirm what other research shows in that these are sentient animals. On that basis, I won't press my amendment at this stage, but I hope we'll get an update before stage 3 from the Minister on the outcome of that research.
Thank you. So just confirm, Colin Smith, you're going to withdraw that amendment.
I'm going to withdraw, Convener, yes.
Thank you. Right, we'll move on. Is the committee content that that amendment has been withdrawn? Thank you. Everyone's content. Okay, moving on. Call Amendment 67 in the name of Colin Smith, grouped with Amendment 99. I ask Colin Smith to move the amendment and speak to both amendments in the group.
Thank you, Convener. I have in my notes that it was number 66 and 63 next, but I could be wrong. Group 3 Convener, Amendment 67 in my name, which I formally move, seeks to create more consistency in the use of disqualification orders. During stage 1, a number of stakeholders highlighted the need for more clarity on when they should be used and indeed when they should not be. My amendment seeks to introduce an automatic lifetime disqualification order for those sentenced to the maximum penalty for animal cruelty, and calls for Scottish ministers to create regulations setting out where they should be used otherwise in order to support consistency and proportionality in their use. I appreciate a disqualification order is not always appropriate or useful, but my amendment also calls for regulations clarifying when disqualification orders should be waived, while making clear that in these instances, the convicting court must state their reasons for doing so. I think this is a crucial point to achieve transparency. I've chosen to take a largely enabling approach here, but recognise the need for flexibility and to give ministers the opportunity to consult prior to issuing regulations. Amendment 99 by Maurice Golden similarly aims to address the concerns raised about the use of disqualification orders, calling for courts to consider a lifetime disqualification for those receiving the maximum penalty and requiring them to provide a reason where they don't. I do not disagree with Maurice Golden's amendment. I believe it would be an improvement on the current law. However, it is not as comprehensive as Amendment 67 in my name, and it does not do anything to clarify the use of disqualification orders out with the rare instances where the maximum penalties are issued. Thank you.
Thank you. I now call on Maurice Golden to speak to Amendment 99.
Thank you, Convener. Amendment 99 relates to the provision of a duty on courts to consider a lifetime disqualification on owning animals for those receiving the maximum penalty for relevant offences. In such circumstances, the court will almost certainly be dealing with the worst cases of animal cruelty. As such, I believe there would be an expectation amongst the public.
Can I just pause for a second? I'm sorry, Maurice, I'm going to have to stop you. I have actually turned over 2 pages instead of 1. And hopefully this is going to be the only mistake I make today. Colin Smith was absolutely right. Had 2 pages stuck together. So I'm going to actually go back and Colin, you were quite correct that it should have been Amendment 66 that we called. So my clerks have just corrected me. So what I'm going to do is just allow Colin a couple of seconds to get himself together. I'd apologise to everyone for that. So I want to call Amendment 66 in the name of Colin Smith, grouped with Amendment 73. And I ask Colin Smith to move Amendment 66.
Thank you very much, Convener. Thank you very much, Convener. The good news is when we do come to number 67, I'll simply refer members to my previous comments. However, Amendment 66, which I formally move, and Amendment 73 in my name, aim to make breaches of laws related to licensing subject to the new higher maximum penalties. The introduction of 5-year sentences for animal cruelty is one of the key aims of this bill. As it stands, it only applies to 2 offences. The rest will remain subject only to 6 months imprisonment or maximum fines of £5,000. My amendments would make the new maximum penalties cover any created in regulations made under Section 27 of the 2006 Act. The enabling powers in Section 27 are very broad and could underpin the creation of a wide range of very serious offences on licensed activities and settings such as breeding, animal sanctuaries and pet shops. The case for higher penalties is as clear here as it is anywhere where there is the potential for harm on a mass scale. Additionally, these offences could involve profitable businesses, which means the fine should be high enough to act as a deterrent. My amendments would increase the maximum penalty for these offences, while crucially maintaining the option of summary conviction and lower penalties. This does not mandate a higher penalty, but simply gives the flexibility to issue one where it is appropriate. Thank you, Convener.
Thank you. And I just want to check no other members wish to speak. No one has indicated that they want to speak. Nope. And I'll now call on the Minister.
These amendments would set the maximum penalties available under animal licensing regulations at the same level as the increased penalties that the bill makes available for the most serious unnecessary suffering in animal fighting offences. And setting a maximum penalty of 5 years in prison and an unlimited fine for all possible future licensing infringements isn't proportionate, and there are other issues. It would prevent Parliament from treating each piece of future licensing legislation on its merits and considering at that time what the most appropriate penalty regime, and in that way it would bind the hands of future parliamentary decision making. And it's also not proportionate because future licensing regimes will likely include offences of varying degrees of seriousness, and it wouldn't be appropriate to dictate that the highest penalties should apply in all circumstances. And just to give an example of that, the proposed licensing legislation on animal sanctuaries, dog, cat and rabbit breeding and pet sales is currently being drafted. And it seems likely that many of the associated offences could be relatively minor and technical in nature and wouldn't directly involve any harm to animals. And just to give you an idea of what some of those offences might look like, I mean, that could include failing to renew a licence or not complying with all the conditions of a licence. So a maximum 5-year prison sentence for failing to renew your dog breeding licence would clearly be excessive. And another very important point is that, as you'll know, the bill introduces the power to develop new fixed penalty notice regimes, which will cater for a wide range of scenarios. And that will be going through the affirmative process, and it will devise the most suitable penalties for each regime. So licensing legislation in particular is likely to be suitable for future FPN regimes, where the offences, as I've already stated, can be relatively minor and technical in nature, and they do not involve direct harm to animals. And it will only be possible to develop FPN regimes for offences where the maximum penalty is no more than 6 months imprisonment or a level 5 fine. So setting the maximum penalty for all future licensing legislation at a higher level would deprive the Scottish Government of the opportunity to develop these in an area where they would be particularly suitable and provide a proportionate, cost-effective way of improving compliance with the legislation. And therefore, that's why I cannot support this amendment, and I would ask the member to withdraw it.
Thank you. I now call on Colin Smith to wind up and to press or withdraw the amendment.
Thank you very much, Convener. I believe, broad and potentially the very serious nature of the offences that can be created under this section mean it is important to provide as much flexibility as possible on fines, and yes, to have a more robust and higher penalty if required. The potential for profit within licensed activities also means higher fines must be on the table so they are a strong enough disincentive. Sentencing guidelines can be used to clarify whether higher penalties are appropriate in order to ensure they are not applied unfairly, just as they will for offences under sections 19 and 23. I acknowledge, however, that someone can be charged with cruelty, of course, in addition to breach of licence. And I'm also conscious the Minister said that there are regulations in the pipeline on dog, cat and rabbit breeding. Other licence regulations are due on pet vending, performance animals and so on. However, the Minister has emphasised that the more minor offences that may be breached in relation to these areas. What I would ask the Minister to do is to make absolutely clear ahead of stage 3 whether or not stronger penalties will be considered as an option as the government develop those further regulations. That is something the government are prepared to at least consider. Then it's not an amendment I will press, recognising of course that I could bring the issue back at stage 3 if the government doesn't give that commitment. So at this stage, it can be that I would ask to withdraw the amendment.
Is the committee happy for that amendment to be withdrawn? If you just let me know in the text box. Thank you, we're all content. Right, now, as previously trailed, I call Amendment 67 in the name of Colin Smith, and that's grouped with Amendment 99. I ask Colin Smith to move Amendment 67 and speak to the amendments in the group.
Thank you very much, Convener. I'll keep my comments very short. There's always a couple here, but in my name, I do formally move seeks to create more consistency in the use of disqualification orders. So I'm therefore happy to move that, and also to support Amendment 99 in Maurice Golden's name, which similarly aims to address the concerns raised about the use of disqualification orders. I don't disagree with this amendment, however, I believe that my amendment 67 is more comprehensive, as it does not do anything to clarify the use of disqualification orders, but with the rare instances where the maximum penalties are issued. So I'm happy to leave it at that, Convener.
Thank you. And I now call Maurice Golden to speak to Amendment 99 and the other amendment in the group.
Thank you, Convener. Amendment 99 relates to the provision of a duty on courts to consider a lifetime disqualification on owning animals for those receiving the maximum penalty for relevant offences. in such circumstances, the court will certainly be dealing with the worst cases of such. I believe that there would be an expectation amongst the public that those involved are not fit to own or indeed care for animals, but also that the best way to ensure future such acts are prevented is to disqualify them from animal ownership. This is a position broadly shared by animal welfare organisations such as the Scottish SPCA, Dogs Trust and One Kind. In such cases, there'd be a mandate on the court to consider a lifetime disqualification and, where one is not imposed, to state the reasons for declining. I believe this is a balanced approach that allows the court some degree of leeway to take account of exceptional circumstances whilst retaining the welfare of animals in sentencing decisions. I also welcome the spirit in which Colin Smith's amendment has been submitted, but I believe Amendment 99 is more workable and practical solution to broadly the same issue.
Thank you. And I see from my screen that Stuart Stevenson is the only member so far that asked to speak in this amendment. I'll go to Stuart Stevenson.
Thank you, Convener. I just make a very technical point that this amendment only addresses the issue of ownership of animals, and that creates, if it were to be passed, and I'm not likely to support it for other reasons, it creates the option, of course, for people having animals in their care whom we would not wish to have care of animals. So I think restricting it to ownership is not an adequate way of drafting the intention of this amendment. Thank you, Convener.
Thank you. I now call on the Minister.
Thank you. So, I mean, just to start off, I completely understand the motivation behind the amendments, and I'm absolutely mindful of the concerns that have been raised about whether disqualification orders should be used more frequently and consistently by the courts than what they currently are already. However, I can't support either of these amendments which would impose or require courts consider a lifetime disqualification on keeping animals for those who receive the maximum available penalty for either animal welfare offences or, in the case of Maurice Golden's amendment, for the full range of animal health, wildlife and wild plant offences as well. Although there are some fundamental problems with the way both the amendments have been drafted, that isn't my principal objection to them. As you'll be aware, under Section 40 of the 2006 Act, courts are already able to issue a disqualification order to ban someone convicted of an animal welfare offence from keeping or owning animals, or from being involved in a wide range of activities which involve animals. And that can be for any time period, which is up to and including a lifetime ban. So that rightly provides the courts with the flexibility to address the particular circumstances of each case and the likely risk that each offender poses to animals in future. And further to that, subsection 5 of section 40 of the 2006 Act already requires courts to state their reasons if they decide not to make a disqualification order for a relevant offence. So that puts the onus on the courts to consider imposing a disqualification order and then explain any decision not to impose a disqualification order. So it does encourage the use of such orders where they're appropriate. Now, disqualification orders are routinely made in animal welfare cases, and I've been informed that in recent years, over half of the court cases that the Scottish SPCA have been involved in have resulted in a disqualification order of some sort, with most of these being for a period of 5 years or more. But I also know that the Scottish SPCA do have concerns about the apparent lack of consistency in the lengths and types of disqualification orders issued by different courts in different cases. However, I know that they also understand and accept that it is a very important and long established principle that sentencing in any given case is a matter for the court. And the courts take into account all the facts and circumstances of a case before reaching a decision within the overall legal framework which is provided by the Parliament. And any new requirement for the courts to follow as they undertake their sentencing responsibilities has to be a matter for the judiciary themselves or for the independent judicially led Scottish Sentencing Council. So for Parliament to place any new obligation on sentencing runs the risk of threatening that judicial independence and should therefore be resisted. And it is worth noting that if and when the changes to the overall sentencing legal framework proposed in the bill are enforced, the Scottish Sentencing Council will be looking at this area with a view to considering the guidelines. And I think that seems to be an appropriate way to proceed, and it doesn't threaten judicial independence. However, in saying all that, I do recognise that this is an area of concern, particularly to Mr Smith and to Mr Golden, who've raised the amendments today. And I would be willing to work with them to consider if it would be possible to make a stage 3 amendment to section 40 of the 2006 Act to strengthen the existing requirement on courts to explain the reasons if they decide not to impose a disqualification order for a relevant offence. So I think if both of the members would be content with that, I would invite them to withdraw their amendments, as I can't support them for the reasons I've outlined at this moment in time.
Thank you. I call on Colin Smith to wind up and to press or withdraw the Amendment 67.
Thank you, Convener. The amendments in this group both try to address what is a clear issue that exists in the use of disqualification orders, and I believe they would both be an improvement. My amendment looks to create as much consistency and clarity in the process as possible, while recognising the need for flexibility. Given this is a complex issue and one that requires proper consultation, I have opted for a largely enabling amendment to allow this work to take place. My aim here is to settle clearly where the appropriate and proportionate use of disqualification orders is, right up to an automatic lifetime ban for the most serious convictions. However, I recognise that a one-size-fits-all approach will not work, and my amendment is clear that there must be a mechanism for waiving a disqualification order where appropriate, provided an explanation is given. As there are 2 amendments, however, on this issue, I'm happy to discuss changes to the specific wording of my amendment ahead of stage 3, and given the assurances from the government over the general aim of the amendment and the willingness to discuss the matter further, I won't press the amendment at this stage. I do wish to make it clear that it is my intention to bring forward an amendment at stage 3, and I hope to work with Maurice Golden and the government to have input into the final wording ahead of that stage. Thank you, Convener.
Thank you. So Colin Smith has withdrawn that amendment. I'll ask the committee members if you are content with that amendment being withdrawn. Yep, everyone is content. That amendment is now withdrawn. Right, I call Amendment 68 in the name of Colin Smith, which is grouped with Amendments 69 to 72. I ask Colin Smith to move Amendment 68 and speak to all amendments in the group.
Thank you, Convener. Can I move Amendment 68 in my name? As with amendments in Group 2, all the amendments in this group aim to expand the offences covered by the increased maximum penalties introduced in this bill. I fully support the introduction of 5-year sentences and unlimited fines for the most serious animal welfare crimes. However, I believe as it stands, this new change is not being applied widely enough. These amendments seek to expand the offences these new maximum penalties apply to. Specifically, Amendment 68 would increase the maximum penalty for offences relating to mutilation. Amendment 69 does the same for the performance of cruel operations on animals. Amendment 70 does so for poisoning offences. 71 for offences related to the failure to ensure the welfare of animals, and 72 to abandonment. There is clearly scope for serious harm under all of these offences, and the current maximum penalty of 6 months imprisonment or a fine of up to £5,000 simply do not reflect that. Increasing the maximum penalty for these offences while retaining the options for a summary conviction and lower penalties will give the flexibility to ensure proportionate sentences can be issued depending on the severity of the crime committed. These amendments shine a light on the diverse nature of cruelty offences and highlights an issue that not all of them are given prominence in terms of sentencing that they should have. I cannot, for example, understand why abandonment is anything other than a cruel offence that should be placed in a higher category in the 2006 Act. The bill brings in fixed penalties for lesser offences, but a fixed penalty for abandonment, for example, would be totally unacceptable given the potential serious outcome of such an offence. If the government is not prepared to accept amendments that bring in these stronger sentences for a wider range of offences, I would hope that consideration may be given to whether an offence such as abandonment should be seen as a lower level offence when it comes to the categorisation of offences. Thank you, Convener.
Thank you. No other members have indicated to me that they wish to speak on that amendment, so I'll call the Minister. Minister.
Okay, thank you. By taking action to increase the penalties for the worst forms of animal cruelty, I think the Government is quite clearly setting out our commitment to properly protect the welfare of animals in Scotland. And the action that we're taking in this bill is bold, and if passed, it could mean imprisonment for up to 5 years for those who commit the most extreme offences, which involve unnecessary suffering or animal fighting, as well as the worst sorts of wildlife crime. Now, fortunately, these kind of horrific cases are rare, but they rightly attract considerable public interest and concern that suitable penalties should be available when they do occur. And I would absolutely acknowledge that some animal welfare groups believe that animal welfare offences of any sort should all attract the strongest possible penalties. However, I do think it's vital that as we take bold action to increase the penalties, we do so in a way that doesn't undermine long-established legal principles, and that includes the need for proportionality between the offence and the sentence. And before going on to set out why it's not proportionate to include these offences within the new penalty regime, I have to highlight from the outset that the most important feature of the 2006 Act is that if the circumstances of any offence involve unnecessary suffering, then they can be prosecuted using Section 19, which has the maximum available penalties under the Act. And that important feature already provides robust protection across the board. Because I'm keen to ensure that as we clamp down on animal cruelty, we retain the long-established and proportionate two-tier approach of having the lesser offences continuing to be subject to a lesser penalty. So the offences in sections 20, 21, 22 and 29 are rarely used in prosecutions. And I completely understand that the terminology that's used within that is very emotive, but I think it's important that we consider what exactly those they often amount to in practice, which tend to be some of the lesser and more technical offences. So, for example, the offence described as mutilation, although that is, again, a very emotive term, it's more accurately about the carrying out of any procedure which interferes with sensitive tissues or the bone structures of an animal. So, to give you an idea what that might include, it could be routine procedures such as microchipping or ear tagging, which are permitted by regulations that control the way that they're done. And accordingly, failure to carry out procedures in accordance with the regulations is an offence under Section 20, and that could include things such as incorrectly inserting an identification ear tag in a farm animal. And regarding abandonment, which Colin Smith mentioned, an offence under Section 29 could include temporarily leaving an animal unattended without making adequate provision for its welfare. That could also mean that no harm is caused to the animal. And in those circumstances, a 5-year prison sentence would, I think, quite clearly be disproportionate. The offence in Section 24 of failing to take reasonable steps to ensure that the welfare needs of an animal are met to the extent required by good practice is most commonly used in prosecutions for behaviour that may affect the welfare of an animal but does not amount to causing unnecessary suffering, because that can often be due to ignorance or misunderstanding rather than the intentional neglect or cruelty. That distinction is very well understood and accepted by the enforcement authorities, which include the Scottish SPCA, local authorities and APHA, who know that if the circumstances of any of those offences involve unnecessary suffering, then again, as I've said earlier, they can be prosecuted under Section 19 and attract that higher penalty anyway. So although the offences we're considering here do have the potential to involve harm to animals, it's vital that our penalty regime is proportionate, and in any case, where unnecessary suffering is actually caused, that the new higher maximum available penalties are already available. And another important point to remember here is that if these amendments go through, again, this is similar to Group 2 in the discussion that we had there, they would prevent ministers from using powers in Section 2 relating to fixed penalty notices, because FPNs can only be exercised in relation to offences where the maximum penalty on conviction doesn't exceed 6 months imprisonment. So this would remove our ability to deal with those lesser offences. So therefore, I'm not able to support these amendments and would urge the committee not to support them either. Thank you.
Thank you, Minister. I invite Colin Smith to wind up and press or withdraw his amendment.
Thank you, Convener. Strengthening penalties for the most serious animal welfare crimes is one of the key aims of this bill. However, if any serious crimes remain subject to a maximum sentence of just 6 months, then this aim is, in my view, not being achieved. It does not make sense that some animal welfare crimes will be subject to up to 5 years in prison and an unlimited fine, while offences such as mutilation, which can be severe, have a maximum sentence of 6 months or £5,000. My amendments do not mean minor crimes under these sections will have to be dealt with differently. Where a short sentence or a small fine is appropriate, that will still be what is issued. This simply means that where a higher sentence is needed, there is the scope to issue one. As indicated in relation to Amendments 66 and 73, there will, of course, need to be clear guidance clarifying where higher penalties are appropriate to ensure they are only used appropriately. I do recognise, however, that in the most severe offences can be charged as unnecessary suffering. The challenge is ensuring that we continue to be and become subject to the new maximum sentence. Equally important is ensuring that acts such as abandonment aren't just covered by fixed penalties. And I don't share the Minister's view that abandonment can be seen as a relatively minor breach of the law. I would therefore welcome further discussion with the government over how this can be achieved. On that basis, at this stage, I won't press Amendment 68 or move the other amendments when the time comes, given that we do have stage 3 and a period of time to discuss the issue before then, Convener.
Thank you. So I'd like to ask committee members if they agree that Amendment 68 be withdrawn. Everyone's in agreement. Thanks. That amendment is now withdrawn. I call Amendment 69 in the name of Colin Smith, which is already debated with Amendment 68, and ask Colin Smith to move or not move.
Not move.
Thank you. I call Amendment 70 in the name of Colin Smith, already debated with Amendment 68. Ask Colin Smith to move or not move.
Not move.
I call Amendment 71 in the name of Colin Smith, already debated with Amendment 68. Ask Colin Smith to move or not move.
Not move.
Thank you. I call Amendment 72 in the name of Colin Smith, already debated with Amendment 68. Ask Colin Smith to move or not move.
Not move.
Thank you. And I call Amendment 73 in the name of Colin Smith, already debated with Amendment 66. Ask Colin Smith to move or not move.
Not move.
Thank you. The question is that Section 1 be agreed to. Are we all agreed? If you're not agreed, simply put a N in the chat box. Otherwise, stay silent. Sections 2 and 3. Okay, we're agreed. The question is that Sections 2 and 3 be agreed to. Are we all agreed? Again, if you're not, put an N in the chat box. We are agreed. Right, move on. I call Amendment 3 in the name of the Minister, grouped with Amendments 4 and 5. I ask the Minister to move Amendment 3 and speak to all amendments in the group. Minister.
Thank you, Convener. Section 4 of the bill at introduction provided for a general power to make provision in regulations for fixed penalty notices to address animal health offences. And the aim is to provide an additional level of enforcement that could be delivered without the intervention of Scottish courts, while still providing a meaningful penalty for those breaching animal health rules. The bill contains provisions to allow Scottish ministers to create such a scheme for minor and technical animal welfare offences, and we consider that similar provisions should be available for appropriate animal health offences too. And that uniformity in approach will provide clarity and consistency, and I think send an important message that we expect all animals in all circumstances to be protected from harm. We held a consultation last autumn to test those proposals further, and the majority of respondents to that consultation were supportive of the principle behind Section 4. Amendment 4 now sets out the detail of how these powers will work in practice. The provisions are subject to strict limits, but they also allow that sufficient flexibility to take account of any future changes to animal health legislation. And Amendments 3 and 5 extend the provisions to include offences under the Bees Act 1980 and offences in any order that are made under that Act. So that ensures that fixed penalty notices can be used where appropriate in respect of offences relating to the control of diseases of kept bees. And I would just want to add that prior to bringing forward secondary legislation to introduce a fixed penalty notice scheme, further stakeholder consultation will be undertaken to help develop the details of the scheme and the range of offences that it would apply to. And any future regulations which make provision for the issuing of FPNs will be subject to affirmative procedure and as such will be scrutinised by Parliament before being made, as is the case with the animal welfare FPN provisions.
Thank you. And I see that Mark Ruskell would like to speak. Mark?
Yeah, thanks, Convener. It's just a brief question for the Minister, and I should probably declare an interest because I'm a beekeeper myself. So it was in relation to the Bees Act 1980. As I understand it, Amendment 3 increases the level of fine upon summary conviction from level 3, £1,000 up to level 5 of £5,000. I just wondered if there are any issues around compliance with the Bees Act 1980. I mean, the Minister outlines the issues about disease control, and I just wondered if there was any concerns that the Scottish Government had that compliance is not high with that Bees Act.
Thank you. So I'll go to the Minister who can address that and wind up.
I mean, this is something that I'd be happy to get back to the committee with more information on. I mean, it's certainly something that I haven't been made of, that there are particular issues with compliance with the Act as it is at the moment, but I do think it is something that's important, is covered by any regime that we bring in, just to ensure that we do have that compliance.
And is the Minister able to want to sum up, or are you quite content for me to move on?
I'm content for you to move on, Convener.
Okay, thank you. So the question is that Amendment 3 be agreed to. Are we all agreed? If you don't agree, please put an in the chat box, please, colleagues. Okay, we are agreed. I call Amendment 4 in the name of the Minister, already debated with Amendment 3. Ask the Minister to move the amendment.
Moved.
The question is that Amendment 4 be agreed to. Are we all agreed? If you don't agree, again, put into the chat box. We are agreed. I call Amendment 5 in the name of the Minister, already debated with Amendment 3, and ask the Minister to move Amendment 5 formally.
Formally moved.
Thank you. The question is that Amendment 5 be agreed to. Are we all agreed? If not, we are agreed. The question is that Section 4 be agreed to. Are we all agreed? We are agreed. Thank you. Right, we now call Amendment 6 in the name of the Minister and a group on its own. I ask the Minister to move and speak to Amendment 6. Minister.
Thank you, Convener. In the course of considering the provisions of this bill, it was brought to my attention that there's an anomaly in Section 15A2 of the Wildlife and Countryside Act in 1981 that governs the use of pesticides and biocides. So the purpose of this amendment is to address that anomaly by extending the defence which is found at Section 15A2 of the 1981 Act to include EU Regulation 1107/2009, which governs the use of plant protection products. So in essence, to extend the legitimate defence to the offence regarding plant protection products. So at present, Section 15A3 of the 1981 Act empowers Scottish ministers to make an order prescribing ingredients of pesticides which it is an offence to possess. This power has been used to make the Possession of Pesticides Scotland Order 2005, which prescribes a list of 8 active ingredients which it is an offence to possess. And though the 2005 order refers to pesticides, the banned ingredients relate to substances that can be used in what are now known as plant protection products. And these are used to protect plants and plant products from pests, diseases and weeds. That could be agricultural pesticides or biocidal products which control harmful or unwanted organisms through chemical or biological means. And just to give you some examples of that, of what the biocides would include, that can be disinfectants, it can be wood preservatives, hand sanitizer and insect repellents. So under Section 15A2 of the 1981 Act, a defence is available to the offence of possession of pesticides if a person shows that their possession was for the purpose of doing anything in accordance with regulations made under Section 16.2 of the Food and Environment Protection Act 1985 or Regulation 528/2012 of the European Parliament and Council. And by way of an example, some of the ingredients in the order can still be used in rodenticides. So a professional and trained pest controller could show that their possession was in accordance with these regulations if they were using the product for its permitted purpose and in full accordance with the conditions that would be governing its use. So this amendment will extend that Section 15A2 of the 1981 Act to ensure that a defence is also available if a person shows that their possession was for the purposes of doing anything in accordance with the regulation that I've mentioned, the 1107/2009 of the European Parliament and Council. This amendment doesn't have any immediate effect because the 2005 order does not currently list any substances approved for use in plant protection products under the EU plant protection product regulations. However, by adding a reference to the EU PPP regime at this time, it will enable us, should the need arise, to add any of the substances covered by it to the 2005 order through secondary legislation. And that's important because it means that it will allow a fast policy response should it be discovered, say for example, that new pesticides are being used for wildlife crimes. This amendment also allows us to add these pesticides to the 2005 order while at the same time preventing the unintended consequence of criminalising a person who legitimately uses a plant protection product under the EU plant protection regime. And with that, I would move Amendment 6.
Thank you. The question is that Amendment 6 be agreed to. Are we all agreed? We are agreed. Call Amendment 74 in the name of Claudia Beamish, which is grouped with amendments as shown in the groupings. Ask Claudia Beamish to move Amendment 74 and speak to all amendments in the group. Claudia.
Thank you, Convener, and I move Amendment 74, and I would like to speak to my amendments and also briefly in relation to Mark Ruskell's amendment as well in the group. This set of my amendments are intended to ensure that those wildlife crimes and crimes against wild mammals which are existent should now also be considered for vicarious liability prosecution where there is evidence of a prosecutable crime. It is important that the owner or the occupier of the land who has the legal right to carry out management activities on that land can be prosecuted for vicarious liability. This could act as a deterrent for those few landowners who do not respect the law. The amendments apply to offences found in the Animal and Countryside and the Wild Mammals Protection Act 1996. I will now outline these in brief and what these offences are. The sale, etc., of live or dead wild birds, eggs, etc., the registration, etc., of certain captive birds, eggs, etc., protection of captive birds, sufficient cage size, protection of certain wild animals, protection of shelters and prevention of poaching, prevention of wild prevention of wild hares in close season, and the protection of certain methods of killing or taking wild animals, prevention of poaching, wild hares, rabbits, etc., protection of wild plants for sale, etc., protection of keeping of invasive animals or plants, and the prohibition on sale of invasive animals or plants, and offences in the Wild Mammals Protection Act 1996, Section 1, which lists the ways in which causing unnecessary suffering to any wild mammal can occur. I took the decision not to include marine mammals in the list, not because they are any less precious, but because ownership is such a complex issue at sea. I note that the Minister has now indicated she will lodge amendments at stage 3 in relation to the killing of seals, so it may be appropriate to discuss with the Minister the application of vicarious liability in this regard with her between stages 2 and 3. And however, I would ask the Minister if she is in a position at this stage to comment on the possible Scottish Government amendment and how this can be consulted on and scrutinised by our committee. I also decided it was not appropriate to include deer in the list, as deer management will continue to demand the appropriate culling of deer, and thus, in my view, this would be too complex to put in the section which is being considered on vicarious liability. I think I have kept the amendments in individual I've made individual amendments. I hope I've done this correctly to give members the choice, and of course the Minister, as to which ones they wish to take forward, if any. These amendments, if passed, should send a strong statement of deterrence across Scotland to all concerned, and I will listen with care to Mark Ruskell's amendment remarks in this group. Thank you, Convener.
Thank you, Claudia. I now call Mark Ruskell to speak to Amendment 95 and the other amendments in the group. Mark.
Thank you very much, Convener. So my Amendment 95 would introduce vicarious liability for offences in relation to badgers. Now, I certainly appreciate and support Claudia Beamish's attempt to apply vicarious liability more widely, but I believe that the case for extension is strongest in relation to badgers. Vicarious liability is about landowners taking responsibility for the actions of those who are working on their property. And badgers face a huge amount of persecution through set destruction. I've heard of a number of cases, including in Fife, within my own region, where it's been difficult to pin down liability when there are contractors, subcontractors, agents, and landowners all passing the buck. Perpetrators get away with set damage because landowners are not liable and because penalties are too low. And in one case in my region, a contractor was simply written a warning letter by the court following the damage of a set. Badger sets are being damaged and destroyed through building works or forestry operations, and I've heard of horrific cases of tunnels being blocked by soil, rocks, trees and brash, suffocating the animals below. There are also examples of estates where multiple donuts have been discovered over a period of time. And a donut is a large circular area of disturbed ground, typically dug by a badger when it's caught in a snare and dies struggling to break free. In one case, 8 donuts were found on an estate stretching back over a number of years. The landowner had clearly avoided taking action to prevent this from happening time after time after time. Now, badgers are territorial animals settling in particular areas. Their presence is easily identifiable through their sets. It's virtually impossible for a landowner to not know that badger sets are there. Law-abiding landowners have nothing to fear from vicarious liability being applied to badgers, but those who allow set destruction and persecution to take place need to know that the buck stops with them. Thanks.
Thank you. And no other members have indicated they wish to speak on either of those amendments. I ask the Minister.
It was widely discussed during the stage 1 consideration of the bill, and I'd said at that point that while I hadn't been able to identify any further offences, which I thought it'd be useful and appropriate to extend the offence of vicarious liability, I would absolutely welcome the committee's suggestions on any particular offences that they felt would warrant it. And I've given very close and careful consideration to all of the amendments that have been brought forward by Claudia Beamish and Mark Ruskell. And I do still have a number of significant concerns with those that I'll lay out to you now. So amendments 74 to 77 extend vicarious liability to a whole range of offences. And I simply just don't believe that the evidence is there to justify that extension. When vicarious liability was introduced as an offence under sections 18A and 18B of the Wildlife and Countryside Act in 1981, it was because we believed that there was clear evidence to demonstrate the need for it in relation to offences against wild birds, their nests and eggs, and the use of banned pesticides. In relation to the amendments, extending vicarious liability to poaching, for example, doesn't make sense because it's often the landowner or the manager themselves who would be the victim of that kind of crime. And likewise, I haven't heard any compelling reasons to demonstrate that vicarious liability is needed for offences related to the protection of wild plants or the keeping or sale of invasive animals, and that there is that employer-employee relationship there where it would be reasonable to hold the employer criminally liable for the acts or omissions of the employee. And do we have the evidence to show that landowners and managers have been complicit in those types of crime? And I don't feel that evidence is there. We need to remember as well that vicarious liability is a type of strict liability offence. So where vicarious liability applies, it's sufficient to show that an employee committed an offence in the course of their employment for their employer to be held criminally liable for the acts or omissions of their employee unless they're able to demonstrate a due diligence defence. So it is a significant step to be opening up vicarious liability to other offences and extending the situations in which vicarious liability may apply. Now, turning to amendments 78, 95 and 96. These amendments open up the possibility of vicarious liability prosecution to be taken against owners or occupiers of land who have a legal right to provide management activities on that land. Now, management activities has a wide-ranging and non-exhaustive definition in the amendment, and as such, it opens up the possibility of a vicarious liability prosecution being brought against a whole host of individuals who wouldn't be liable under the existing provisions that we have in the Act. So while we discussed at stage one the possibility of extending the offences to which vicarious liability could be applied, there weren't any discussions on widening the definition of who it could be applied to. So I do think it would be inappropriate to make those far-reaching changes like this without having first engaged in a consultation or looked at the full impact assessments so that all of the implications and ramifications of such a change could be fully understood. And I think it's also important to remember that it is already an offence for someone to knowingly cause or permit an offence to be done in relation to sections 6, 7, 9, 11 and 13 of the 1981 Act, as well as sections 1 to 4 of the 1992 Act. Now, admittedly, that doesn't go as far as vicarious liability, but it does mean that should an employer or land manager instruct an employee to commit one of those offences, then they would be liable for that offence. Now, having said all that, I do think there could still be potentially some offences within the list of amendments there that we could consider further ahead of stage 3, but I couldn't support the amendments as they are and the way that they're drafted at this current time. And just to raise another point that was raised by Claudia Beamish in relation to the letter that I sent committee and stage 3 and seals. Again, this is something, it's not an ideal situation, and this is not something that we would ordinarily do. In that letter, I did offer the opportunity for officials to discuss that further with committee, if that's something the committee would wish to discuss further. So I do hope that you could potentially take officials up on that offer to give you more detailed information about the potential for that amendment.
Thank you, Minister. And Finlay Carson would like to come in and speak on this.
Thank you, Convener. Just to add to the words of the Minister, we strongly disagree that the new provisions of vicarious liability in this instance add anything to the existing laws. We don't accept the extension in terms of the bill, because it would appear to make the landowner liable for the actions of third parties, irrespective of whether he or she has taken due care of and attention. And we absolutely accept the legal principles of liability and agree that landowners can and should be held responsible in certain circumstances. However, what this amendment appears to be doing is making the landowner liable for the actions of third parties, whether they've taken any due care and attention at all. So we won't be supporting these amendments.
I'd like to give the opportunity for the Minister to come back on any of that, or are you happy to move on? Thank you. Right, I ask Claudia Beamish to wind up and press or withdraw her amendment.
Right, thank you, Convener, and I thank those who've contributed to the debate as well. I wanted to, before telling the committee what my decision is on my own amendments, to, if it's appropriate, Convener, to simply comment very briefly on Mark Ruskell's, if I'm allowed. I think that badger sets are something that that a landowner would definitely know the existence of, or could very easily be informed of the existence of, by those who are managing the land. And I think that there, as Mark Ruskell highlighted, there have been some very serious cases of this. So I would simply say that I think this is something that is important. And I note what the Minister says about poaching and invasive plants, and I take that point on those amendments. In terms of 78, 95 and 96 and the legal right to management activities, as this is widening definition, I think certainly I wouldn't want to take those amendments forward today. As the Minister's highlighted, that consultation would be needed. But I would hope that in relation possibly to the section on traps and snares, that it might be possible for the Minister to consider something in relation to vicarious liability before stage 3. But I don't know, Convener, if it's possible for the Minister to comment on that, or if I've left that too late.
No, I'm happy for the Minister to come in and answer that. Minister?
Yeah, that's certainly one area I'd be happy to discuss with Claudia Beamish further ahead of stage 3.
Okay.
Right, thank
Claudia,
you.
can I ask you if you wish to press or withdraw Amendment 74?
I wish to withdraw the amendment today. Thank you.
Thank you very much. Is the committee content that the Amendment 74 be withdrawn? We are content. We're agreed. So I call Amendment 75 in the name of Claudia Beamish, which is already debated with Amendment 74, and ask Claudia Beamish to move or not move.
Not move, Convener.
Thank you. I call Amendment 76 in the name of Claudia Beamish, already debated with Amendment 74, and ask Claudia Beamish to move or not move.
Not move.
Yeah. Call Amendment 77 in the name of Claudia Beamish, already debated with Amendment 74, and ask Claudia Beamish to move or not move.
Not move.
Thank you. I call Amendment 78 in the name of Claudia Beamish, already debated with Amendment 74, and ask Claudia Beamish to move or not move.
Not move, Convener.
Thank you. Call Amendment 7 in the name of the Minister, grouped with Amendment 9, and ask the Minister to move Amendment 7 and speak to both amendments in the group. Minister.
Thank you, Convener. In the course of considering the provisions of this bill, it was brought to my attention that it needs to be updated to be brought in line with recent amendments to Section 21 of the Wildlife and Countryside Act 1981, which provides the penalties for the offences within that Act. So without this update, there would be a discrepancy in the section that provides penalties for all of the offences in Part 1 of the 1981 Act. So after this bill was laid in Parliament in September last year, the Wildlife and Countryside Act in 1981 was amended by secondary legislation in order to enact the new EU invasive alien species regulations. The SSI made changes to some sections within the 1981 Act concerning the control and release of invasive non-native species, and it inserted a new offence of contravention of EU Regulation 1143/2014, which covers the prevention, management, introduction and spread of invasive alien species. As the bill was drafted prior to the SSI being laid, it doesn't include penalties for the offences inserted by those regulations. So therefore, as it stands after commencement of the bill, if these amendments aren't made, then the provisions wouldn't make sense, given the present drafting in the bill is based on how Section 21 of the 1981 Act was set out prior to it being amended by the 2019 regulations. And at the same time as that, we'll increase the maximum penalties for the new offences so that they attract the same maximum penalties as the similar existing offence in Section 14 of the Act, which also deals with invasive alien species. And that would allow sheriffs to issue equivalent sentences in cases where multiple offences have been carried out across the 1981 Act. And with that, I would move Amendment 7.
Thank you. And no members have asked to speak in this amendment. The question is that Amendment 7 be agreed to. Yeah, unless the Minister wants to say anything else. No. Question is that Amendment 7 be agreed to. Are we all agreed? We are agreed. Call Amendment 8 in the name of Claudia Beamish, grouped with amendments as shown in the groupings. And I ask Claudia Beamish to move Amendment 8 and speak to all amendments in the group. Claudia.
Thank you, Convener. This group is about increasing maximum penalties, and it looks to focus on offences relating to breeding sites and resting places as found in the Wildlife and Countryside Act 1981 Section 1, and for offences relating to illegal pesticides as found in the same Act Section 15A. I'd like to thank RSPB, SWT and evidence from Link and the Bat Conservation amendments. The designated offences would now have a new summary conviction to imprisonment for a term of not exceeding 12 months or a fine not exceeding £40,000 or both, and if conviction on indictment, to imprisonment for a term of not exceeding 5 years or a fine or both. Members may note Amendment 10 differs from the rest in terms of sentencing, and I would like to be considered for withdrawing this amendment with the permission of members, as I put this in as an error, and I apologise. A breakdown of the offences I wish to include are in relation to the intentional or reckless damaging, destroying, obstructing nests and nests that are habitually used, taking or destroying eggs of certain wild birds, possession of certain dead wild bird or its eggs, disturbing nest building or nests with eggs or young or birds with dependent young, disturbing lekking, which I found out is the competitive displays to attract mates, harassing any wild bird in Schedule 1A, specified list of birds of prey, damaging, destroying, obstructing shelter of certain wild birds, disturbing certain wild animals while occupying shelter, possession of pesticides containing one or more prescribed active ingredient, and knowingly causing or permitting the possession of said illegal pesticides. So that's the list, and in the Stage 1 report, the committee recommended that the Scottish Government reconsiders its approach to resting places and breeding sites as crimes, as these can have equivalent outcomes, with the destruction of a habitat could be as fatal as directly harming or killing an animal. And so the unlimited fine is particularly vital, as there are cases where offenders can benefit financially from not following the law where the development of land, etc., also provide alternative roosting sites, can have a cost greater than the existing fine. I appreciate the government's comments on potential further amnesty on illegal pesticides, but I would consider that enough time has passed since these were banned, and that their possession or causing someone else to possess them, that their illegality will be well known, and so should be considered a serious crime with a penalty that could properly deter. These crimes can be a source of immense suffering in wild animals, and an increase in penalties will appropriately recognise the sentience of wild animals and help to better deter the knowing harm to them. Thank you, Convener.
Claudia, could you please move Amendment 8?
Thank you, Convener. I move Amendment 8.
Thank you. And no other members have asked to speak on that amendment. I'll now come to the Minister.
Thank you, Convener. The continued illegal use of pesticides to poison animals and the extremely toxic nature of some of these substances doesn't just pose a danger to domestic and wild animals, but also to human health. And the appropriate level of penalty for the possession of banned pesticides was, as Claudia Beamish highlighted there, raised by the committee during stage 1. And I said then that I was open to considering an increase to the maximum penalty. And following careful consideration of the evidence, I'm happy to support Amendments 8 and 11 to increase the maximum penalties for the possession of prescribed pesticides to 12 months imprisonment or £40,000 fine, or both by summary procedure and 5 years imprisonment and or an unlimited fine by solemn procedure. Now, turning to the amendments concerned with the disturbance of nests and habitats, I firstly want to make one technical comment in relation to these amendments by drawing the committee's attention to the fact that these amendments as drafted don't repeal the penalties for these offences set out in the bill at introduction. So if these amendments are passed as they're currently drafted, the offences will have 2 conflicting maximum penalties. So that would, of course, make the legislation unworkable. But now looking at the purpose of the amendment, I do share Claudia Beamish's concerns about the impact that offences involving the disturbance of nests and habitats can have on our wildlife. And that's why I'd initially proposed at the outset of the bill to increase the maximum penalties for these offences to 12 months imprisonment and or a £40,000 fine, or both. However, I appreciate that there is that view amongst the committee members and amongst many other MSPs and stakeholders that these proposals don't go far enough, and that the impact of some of these offences can be significant, and therefore they would warrant that higher penalty. So, as I've said all along, I'm more than willing to listen to and work with the committee and Parliament to make sure that this bill affords the best protection for our wild and domestic animals. So while I can't support all of the amendments in this group as they currently stand due to those technical issues that I'd previously highlighted, after listening to the arguments that have been put forward, I would be prepared to give the amendments relating to the disturbance of nests and habitats further consideration ahead of stage 3. So therefore, I would support amendments 8 and 11, and if Claudia Beamish is willing to withdraw the other amendments in this group, I will give her my commitment to work with her on the possibility of an amendment at stage 3.
Thank you, Minister. Now call on Claudia Beamish to wind up and press or withdraw Amendment 8.
Right. Thank you, Convener, and I'm very relieved to hear what the Minister says about illegal pesticides. I would like to press Amendment 8. I think the time has come where that recognition is out there, and there is absolutely no excuse for storing or making use of these very dangerous chemicals to animals and to our environment. In terms of the other amendments, I would be pleased to work with the Minister and other members and those stakeholders who have expressed an interest in concerns about nests and resting places, and I recognise that the amendments will need looking at again, whichever ones are taken forward at stage 3, because they don't repeal previous provision, which I think, of course, would not be appropriate. So I hadn't been aware of that, and that's useful. So I thank the Minister for that comment. I think Habitats and resting places are fundamentally important to so many animal species, and to give better protection through this Act at stage 3 will be something that I look forward to working with the Minister on. So I don't intend to take forward those amendments today, Convener. Thank you.
Thank you. The question is that Amendment 8 be agreed to. Are we all agreed, colleagues? We are agreed. I call Amendment 9 in the name of the Minister, already debated with Amendment 7, and ask the Minister to move it formally.
Moved.
Thank you. The question is that Amendment 9 be agreed to. Are we all agreed? We are agreed. Call Amendment 10 in the name of Claudia Beamish, already debated with Amendment 8, and ask Claudia Beamish to move or not move.
Not move, Convener.
Yeah. I call Amendment 79 in the name of Claudia Beamish, already debated with Amendment 8, and ask Claudia Beamish to move or not move.
Not move.
Call Amendment 80 in the name of Claudia Beamish, already debated with Amendment 8, and ask Claudia Beamish to move or not move.
Not move.
Thank you. Call Amendment 81 in the name of Claudia Beamish, already debated with Amendment 8, and ask Claudia Beamish to move or not move.
Not move.
Thank you. Call Amendment 82 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
Thank you. I call Amendment 83 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
Thank you. Call Amendment 84 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
Thank you. Call Amendment 85 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
I call Amendment 86 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
Okay. I call Amendment 87 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
Call Amendment 88 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
Call Amendment 89 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
Call Amendment 90 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Not move.
Call Amendment 11 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Moved, Convener.
Thank you. The question is that Amendment 11 be agreed to. Are we all agreed? We are agreed. I call Amendment 91 in the name of Claudia Beamish, already debated with Amendment 8, Claudia Beamish to move or not move.
Move, Convener.
Question is that Amendment 91 be agreed to. Are we all agreed? If you would like to go to the chat box. No, hang on a second. Right, so we have a division here. Yeah. Okay, we're not agreed. We'll need to go to a vote. Right, using the chat box, colleagues. Those who are for Amendment 91, please let me know now in the chat box. Those who are against? And do we have any members wishing to abstain? I don't think we do. Okay, if you just give me a second while we collate these votes. Okay, we have the results of the votes. So we have total votes for 4 members, total votes against 3, and no abstentions. I'll just go through how the votes went. So I voted against the amendment. Angus MacDonald was against. Stuart Stevenson was against. For the amendment, Finlay Carson, Annie Wells, Claudia Beamish and Mark Ruskell. So the amendment is agreed to. That's Amendment 91 is agreed to. The question is that Section 5 be agreed to. Are we all agreed? We are agreed. Right, I call Amendment 92 in the name of Colin Smith, grouped with Amendments 93 and 94, and I call on Colin Smith to move Amendment 92 and speak to all amendments in the group.
Thank you very much, Convener. I'm pleased to move Amendment 92 in my name. All the amendments look to increase maximum penalties for interfering with or damaging a badger set to bring it into line with the penalties for harming a badger directly. Interfering with a badger set can cause at least as much damage as killing them directly, and often more, by causing elongated suffering, more drawn out and painful deaths, or by harming entire groups of badgers and risking local extinction. The disruption of badger sets causes badgers to be crushed, suffocated and drowned, and dependent cubs are left vulnerable when adults desert damaged sets. Because the fines for these offences are currently so much lower than those for killing a badger directly, people can often choose to damage sets with the aim of killing badgers. Indeed, there is no reason for damaging a badger set other than to harm the animals, and that needs to be reflected in the penalties. The current penalties are clearly not acting as a strong enough deterrent. Scottish badgers receive up to 100 incident reports a year, around 80% of which can be considered potential offences, and the majority of these are offences against sets rather than badgers. As drafted, these amendments would retain the option of summary convictions and lower penalties. I believe there is a case to be made for removing this option altogether. However, in the interest of compromising and seeking agreement on this issue, I have not suggested doing so at this point. This means if these amendments were passed, there would still be a great deal of flexibility available in how these cases can be dealt with, depending on their severity and the impact of the crime, and that is an important point. However, increasing the maximum penalties for these crimes to bring them into line with offences against the animal will reflect the significant scope for damage from these crimes and send a clear message that disrupting a badger set is a serious wildlife offence. This will both ensure that serious crimes receive appropriate penalties and will help act as a deterrent for those who see badger sets as an easy target compared to the animals themselves. Thank you, Convener.
Thank you. And I just asked Colin Smith if he would like to move Amendment 92.
To move the amendment, Convener, yes.
Thank you. And we have Mark Ruskell wanting to speak to this amendment. Mark.
Yeah, thanks, Convener. Very much welcome this amendment. I think we need to see the increase in penalties for destruction of badger sets as a package alongside the provisions for vicarious liability. We need to ensure that these penalties are in line with other offences. And I think it's worth bearing in mind that, you know, some of the landowners, some of those who are responsible for set destruction are particularly wealthy. We're talking about, you know, commercial interests, corporate interests, and the level of penalties that exist at the moment I mean, even if we can get a conviction, again, that brings in the case of vicarious liability again, but even if we can get a conviction, the levels of fine that are attributed to set destruction are so low that in many cases they would barely register on a business's balance sheet. So we need to increase these penalties and vicarious liability in order to bring an end to the destruction of badger sets that's happening across Scotland at the moment. Thanks.
Thank you. No other members have indicated that they wish to speak on this, so I will go to the Minister.
Thank you, Convener. As I'd said when I was considering Claudia Beamish's amendments, I absolutely appreciate the impact that offences involving the disturbance of habitats and resting places, including badger sets, can have on wildlife. And that's, again, why I proposed at the outset of the bill to increase the maximum penalties for these offences to 12 months imprisonment and or a £40,000 fine, or both. But again, I've listened to the concerns raised today, and I'd be prepared to give these amendments further consideration ahead of stage 3. And therefore, I would just simply ask the same as what I'd asked of Claudia Beamish. And I would ask Colin Smith to withdraw the amendments to this group, and I would look to work with him on the possibility of an amendment at stage 3.
Thank you, Minister. I now call on Colin Smith to wind up and press or withdraw his amendment.
Thank you, Convener. It's simply not right that crimes against badger sets aren't subject to the same penalties as crimes against the animal, when in reality a crime against a set are crimes against animals. These amendments will close that loophole that allows people to kill an entire group of badgers in a cruel and inhumane way with less severe consequences than killing an individual badger. These amendments would retain the option for a summary conviction with lower maximum penalties, so where appropriate they can continue to be dealt with in the same way they currently are. They would, however, allow for stronger penalties to be applied where it is necessary, and we know there are circumstances where it is necessary. We do not go any further than bringing offences against badger sets into line with offences against badgers, which reflects the true impact of these crimes. I take on board what the Government Minister says. I'm happy not to press the amendment at this stage, but to make very clear that the aim of any amendment at stage 3 has to be to bring these crimes against badger sets into line with crimes against the animal itself. So I'm happy to work with the Government on any wording issues they may have over a stage 3 amendment. So I won't press at this stage, but certainly intend to pursue this matter at stage 3. Thank you.
And you're withdrawing the amendment?
Withdrawing the amendment, yeah.
I'd just like to put on record my support for the policy intention in this as well. I spoke on this on the stage 1 debate, and I agree with all the comments that have been made about the impact of destruction of badger sets on the animals. So thank you for that. So that amendment is withdrawn. The committee content that that amendment is withdrawn? We are agreed. Call Amendment 93 in the name of Colin Smith, already debated with Amendment 92. Ask Colin Smith to move or not move.
Not move.
Thank you. I call Amendment 94 in the name of Colin Smith, already debated with Amendment 92, and ask Colin Smith to move or not move.
Not move.
I call Amendment 95 in the name of Mark Ruskell, already debated with Amendment 74. Ask Mark Ruskell to move or not move. Can I ask Mark Ruskell again? The microphone wasn't quite unmuted.
Moved.
Moved. The question is that Amendment 96 be agreed to. 95, sorry. Yes. A typo. Are we right? Okay. The question is that Amendment 95 be agreed to. Are we all agreed? Okay, we're not agreed. We are going to have a vote. Right. Could I ask all members who are in agreement with Amendment 95 to say so in the chat room now? And those against? Do we have any abstentions? Okay, just give me a minute just to get this out. That's a typo. We have the results of the vote on Amendment 95. There were 2 votes for, 5 votes against. I'll just do a roll call of how those votes broke down, and there were no abstentions. So against Amendment 95, we have myself, Angus MacDonald, Stuart Stevenson, Finlay Carson and Annie Wells. And for the amendment, we had Claudia Beamish and Mark Ruskell. Therefore, Amendment 95 is disagreed to. The question is that Section 6 be agreed to. Are we all agreed? We are agreed. The question is that Sections 7 and 8 be agreed to. Are we all agreed? We are agreed. Call Amendment 96 in the name of Claudia Beamish, already debated with Amendment 74. Claudia Beamish, to move or not move?
Not move, Convener.
Thank you. The question is that Section 9 be agreed to. Are we all agreed? We are agreed. The question is that Section 10 be agreed to. Are we all agreed? We are agreed. I call Amendment 12 in the name of the Minister, grouped with Amendment 64, and ask the Minister to move Amendment 12 and speak to both amendments in the group.
Thank you, Convener. The aim of this bill is to create a suite of measures to deal with offences against animals, and the bill at introduction contained provisions that allow Scottish ministers to create a fixed penalty notice scheme for minor and technical animal welfare offences. And Amendment 12 seeks to introduce the same provisions but for wildlife offences, bringing the protections of wildlife into line with that of domestic animals. And it will enable the Scottish Government to bring forward secondary legislation in future to create a fixed penalty notice scheme for minor and technical wildlife offences. And this amendment limits the offences that fixed penalty notices can be applied to those that carry a maximum penalty of 6 months imprisonment or a level 5 fine. This bill already contains a provision to confer a power on Scottish ministers to make regulations for the use of fixed penalty notices in relation to animal welfare offences. The merits of this regime have been discussed at stage 1, and the committee, I think, initially welcomed that proposal, and this amendment extends that agreement to wildlife offences. But again, just to remember that prior to bringing forward second legislation to introduce an FPN scheme, we will undertake further stakeholder consultation to help develop the details of that scheme and the range of offences that it would apply to. Any future regulations which make provision for the issuing of fixed penalty notices will be subject to the affirmative procedure, and as such they will be scrutinised by the Scottish Parliament before being made, as is the case with the existing animal welfare FPN notice provisions. And with that, I would move Amendment 12.
Thank you. No other members have indicated that they wish to speak in this, and I'm assuming the Minister doesn't want to wind up. Thank you. The question then is that Amendment 12 be agreed to. Are we all agreed? We are agreed. Okay, I call Amendment 1 in the name of Mark Ruskell, grouped with Amendment 98. I ask Mark Ruskell to move Amendment 1 and speak to both amendments in the group. Mark.
Thanks very much, Convener. So this amendment follows up on one of the many recommendations of Professor Pouncesty's review that we're discussing here today, and it recognises that the causes of violence against animals may be deep-rooted in a person's upbringing, and that their lack of empathy could be as a result of fear and violence in their own lives. Rehabilitation and reintegration back into society are important outcomes for the criminal justice system, but there are no empathy training courses available in relation to animal welfare offences, despite intervention programmes such as the SSPCA's Animal Guardians programme being available for young people who are starting to show offending behaviour. Now, courts want to apply restorative justice approaches, and there was a recent case of two young people who put a lizard in a kitchen blender and killed it. The judge wanted to send them on an empathy course, but unfortunately no courses were available. So my amendment number 1 simply requires ministers to take such steps as appears to them to be required to facilitate the development of programmes. Now, this could be funding and guidance as specified directly in Claudia Beamish's Amendment 96, but under my Amendment 95, this is at the discretion of the Minister. Thanks.
Thank you. No other. Oh, Mark, you haven't moved your amendment. If you could just do so.
Thanks, Convener. I move Amendment 1.
Thank you. Now calling Claudia Beamish to speak to Amendment 98 and the other amendment in the group. Claudia.
Thank you, Convener. And Amendment 98 puts an obligation on the Scottish Government to ensure there is guidance developed and funding available as appropriate to enable sentence disposals of empathy training and restorative justice services available to the courts, where judged to be appropriate for those convicted of animal crimes in the listed acts. These programmes could well break what in some cases have been intergenerational negative and inappropriate behaviour patterns towards animals. The guidance must be laid before Parliament. While my other amendments today have looked at deterrents and dissuasive sentencing, this amendment looks at an approach that could be used alongside sentencing to develop empathy in offenders, which may prevent future offending and thereby protect animals better. Violence to animals and to humans, it should be recognised, can on occasion be linked, and this goes forward to other amendments, such as that on letting other groups and statutory organisations know of an offender's behaviour. This amendment could mean that the offender has to face the reality and consequences of his or her actions to better understand the wrongness of it. Members will remember from stage 1 that there are parallels which were raised with speeding offences. There are also parallels with domestic abuse offenders who in some cases have been able to take part in the Caledonian system while in prison, and this has been funded by the Scottish Government in part. My thanks go to One Kind for their work on this issue and help with this amendment. Animal cruelty convictions clearly need to effect changes in attitudes, and One Kind highlight the Scottish Government's 2007 report that suggests community-based sentencing can have more effect in some cases in preventing recidivism. One Kind is working in this area and hopes to promote the development of a suitable programme or course if this amendment were to pass. And I'm also supportive of Mark Ruskell's amendment and the relationship that this has to the discretion that the Scottish Government and, of course, the courts could have with restorative justice and also empathy training. Thank you.
Thank you. And no other members have indicated to me that they would like to speak on those amendments, so I'll go to the Minister.
Thank you, Convener. I know that both of these amendments, they look similar at first glance, but of course they are different in the detail, and I have carefully considered them, and I feel I'm not able to support them for three main reasons. Firstly, and primarily because I understand that local authorities already have the powers to organise a range of community payback order requirements, and courts already have the ability to order them as part of sentencing. Secondly, I'm not too sure if it's necessary or necessarily a justifiable use of resources to oblige the government to make community payback order programme requirements of the very detailed type described available to all offenders convicted of the full range of animal welfare or wildlife offences. And finally, I can't support the amendment because of the extent to which it could constitute an interference with the long-established principle that government should not interfere in judicial decision-making. I think to take the first point, we should consider what community payback orders run by local authorities currently involve at present. Because before a sheriff or judge can sentence somebody to a community payback order, they have to first obtain a report from a criminal justice social worker. And the report will give the sheriff or judge background information about the person, such as any offences they've previously committed, their risk of offending again, their health and living situation, and other such information. The criminal justice social worker is assigned by the local authority to supervise the different requirements of the community payback order. And there are 9 different requirements that can be given, and it's a matter for the sheriff or judge to decide which ones should be selected for each sentence. And that could be along the likes of an unpaid work requirement, a drug treatment requirement, or a programme requirement, which is what we're considering here today. If a programme requirement is attached to the community payback order, the person convicted of the offence could be ordered to attend a programme arranged by a social worker. And these deal with offending behaviour and can cover a range of issues. And there is very little evidence that specific animal welfare empathy programmes are beneficial in these circumstances. And I think without that crucial evidence on effectiveness, I'm not convinced that it would be a good use of either national or local authority resources to develop and provide those highly specific programmes that the amendments would be asking for. The powers already exist for local authorities to develop relevant programmes on a non-statutory basis, and I think that you could arguably say that that's a more appropriate approach with evidence gathered of impact on organisations involved, looking at the capacity to deliver, priority and effectiveness. The programmes would be designed and offered by local authorities in collaboration with partners, and their use remains a matter for the courts considering the individual circumstances of each offender. And those programmes could already include the restorative justice approach referred to in Claudia Beamish's amendment, where both the offender and the victim, or potentially for animal-related cases, their owner or other representative, agree to participate voluntarily to understand and acknowledge the harm that the offence has caused. So in that regard, the Scottish Government has already set a clear vision of having restorative justice services widely available across Scotland by 2023, with the interests of victims at their heart. The government provided £300,000 of support to support delivery when the Restorative Justice Action Plan was published in June last year, and additional funding will be available in the current financial year also. In any case, people convicted and sentenced to any community payback order with supervision, whether that's for an animal welfare offence or indeed most other offences, they'll already have a risk assessment and an action plan which would focus on addressing the offending behaviour and attitudes to offending and so on, without the need for a programme requirement as such. The Scottish Government does, of course, strongly support the principle of empathy training as a preventative measure, and we consider that that is a very important area to focus on. And there are a number of initiatives around teaching children empathy, which is centred on kindness to both people and or animals. And in particular, we've supported the Roots of Empathy programme for some Scottish schools. And Roots of Empathy is an evidence-based classroom programme that has shown significant effect in reducing levels of aggression among school children by raising that social and emotional competence and increasing empathy. And Scotland was the first country worldwide to deliver Roots of Empathy in every council area, and that followed from £1.2 million worth of funding. And I know that the Scottish SPCA have also done a significant amount of work in this area through visits to schools and in programmes that intervene with children and young people who are potentially starting to display those offending behaviours. And particularly towards animals, such as their Animal Guardians programme. And turning to the final point that I'd made on judicial interference, I think this is particularly relevant with regards to Claudia Beamish's amendment, which would require guidance to be issued to courts. And it is a long established and important principle that sentencing in any given case is a matter for the court alone. The courts take into account all the facts and circumstances of a case before reaching a decision within the overall legal framework. And any guidance for the courts as they undertake their sentencing responsibilities should be a matter for the judiciary themselves or the independent judicially led Scottish Sentencing Council. And I think to oblige Scottish ministers to provide guidance to the courts on sentencing matters runs the risk of threatening that judicial independence, and it should be strongly resisted. However, it is worth noting that the Independent Sentencing Council has indicated as part of their current business plan that they intend to consider sentencing guidelines in the area of wildlife and environmental offending. So if and when the changes to the overall sentencing legal framework proposed in this bill are in force, the Scottish Sentencing Council will be looking at this area with a view to considering guidelines, and I think that's the correct order in which these issues should be considered. However, I would add that in saying all that, I do think that there is scope for us to consider further the prospect of restorative justice as it applies to animal welfare and wildlife cases. And we could potentially undertake a project to look at the latest evidence from other countries in relation to that. And I think if we can commit to further investigating that, I don't know if the members would be willing to withdraw their amendments on that basis so that we could take forward further discussions about what that could look like.
Thank you, Minister. And I'll ask Mark Ruskell to wind up and press or withdraw his amendment.
Yeah, thanks, Convener. I listened carefully to that. I would certainly be interested to hear more at some point from the Minister about what a project might look like. I mean, I think the problem here is that we're stuck in a bit of a chicken and egg scenario. Yes, there isn't the direct evidence about empathy training being successful in a restorative justice approach, but that's partly as a consequence of there not being any empathy training and restorative justice programs available for people, offenders, to actually go on. And yes, the Minister's right to point out, as I did in my opening comments, about some of the empathy training that's available for young people in schools, but we're not seeing the rollout of this kind of approach under CPOs. And I think, we have to question, why isn't that happening? The Minister talked about resources. I mean, this is a fairly specialist type of rehabilitation, and it could be that perhaps local authorities, on their own are not able to, pursue a bespoke course within an area where you may have quite low numbers of offenders that would go on such a course. So it does really need a nationally coordinated approach, and I would hope that the government would be able to move on something. I mean, I take on board the Minister's comments about guidance in relation to Claudia Beamish's amendment. I mean, that's why with my amendment, number 1, attempted to put something that was very light touch into legislation, but nevertheless ensuring that the government does actually take action on this. So I look forward to further discussion with the Minister on this ahead of stage 3. I'll not press the amendment number 1 today, and we'll have a look at what the scope might be for action to be taken on a non-statutory basis. And we'll look at a specification for that, and I'll consider whether, on the back of that discussion, whether it would be worth putting something forward for stage 3 or not. That's not moved, Dana.
So that amendment is withdrawn, Mark?
Yeah, withdrawn.
Thank you. And are committee members content for that to be withdrawn? Right. We are agreed on it being withdrawn. Call Amendment 98 in the name of Claudia Beamish, which has already been debated with Amendment 1, and ask Claudia Beamish to move or not move.
Convener, I don't intend to move, and noted the comment of the Minister about possible discussions. Thank you.
Thank you. Right, I call Amendment 97 in the name of Colin Smith. That's in a group all on its own. Can Colin Smith move and speak to Amendment 97?
Thank you, Convener. Amendment 97 in my name, which I move, is intended to create a framework for more efficient information sharing on animal welfare and wildlife-related crimes in response to concerns raised to the committee on this at stage 1. A number of stakeholders noted that the lack of information sharing on these offences inhibited investigations and made it difficult to track offenders and identify patterns of behaviour. Indeed, the committee's stage 1 report concluded that, and I quote, that information sharing on convictions may help track patterns of offending, including animal welfare and other forms of offending such as domestic abuse and criminal activity, and it recommended that the Scottish Government set up proposals to establish a registration system or a means of effectively sharing information between authorities. My amendment seeks to underpin the creation of such a system. I've taken an enabling approach, simply calling on the Scottish Ministers to issue guidance on the issue in order to give us as much flexibility as possible on the specifics of the system. However, the aim here is an incredibly important one, and I hope that we can agree on this straightforward amendment as a first step towards addressing this problem. Thank you, Convener.
Thank you. And Stuart Stevenson would like to speak on this. Stuart.
Thank you very much, Convener. It's probably a question for the Minister as much as it is for Colin Smith, although it would be proper for Colin to comment as well. It simply leaves me uncertain about how this interacts with the operations of Disclosure Scotland, in particular in relation to community payback orders, disqualification orders, and so on. And I just welcome, if this were to pass, and I'm not minded for the moment to support this, how Disclosure Scotland fits in. For example, in the section Enforcement Authority does not list Disclosure Scotland. That may be correct or not, but I think there are issues with drafting besides any that may arise in the policy.
Thank you, and I'll go to the Minister. Minister.
Thank you. I just want to state at the outset that I absolutely support the aims of the amendment in principle, because the government recognises the importance of improving information sharing and coordination between the various bodies who have a role in animal health, welfare and wildlife enforcement, and that includes local authorities, APHA, Food Standards Scotland, Scottish SPCA, Police Scotland and others. Officials are currently involved in ongoing discussions with enforcement bodies on this subject, and I've been informed that there are current moves to standardise the databases used by Scottish local authorities and others, and to agree protocols for greater sharing of information between the various bodies involved in the wide range of animal health and welfare enforcement. And that includes many forms of information and intelligence, and not just limited to the outcome of criminal cases. We will, however, have to carefully consider if the amendment proposed would actually produce the improvements we'd like to see, and if it would be legally feasible, because there are various legislative competence issues which would need to be worked through. So a particular issue is to what extent this would constitute a direction from Scottish Ministers to Police Scotland, which would be contrary to the proper process and could amount to an unacceptable interference by the government in the independent system for the investigation and prosecution of crime in Scotland, which is headed by the Lord Advocate. And any guidance issued to enforcement authorities would also need to comply with data protection legislation. For example, there would be a need to ensure that personal data would be processed lawfully, fairly and in a transparent manner and collected for specified, explicit and legitimate purposes only. And we would also need to consider whether anything should be added to the provisions to ensure that they comply with Article 8 of the European Convention on Human Rights, because that concerns the sharing of information about the private lives of individuals. So, and I think Stuart Stevenson highlighted a couple of points there as well. And I think because it's for these reasons that I can't support the amendment as it's currently drafted, because there are very fundamental and complex legal issues involved in it. But again, I would like to offer to work with Colin Smith on whether the aims that we do both share of improving information sharing and coordination between enforcement authorities in general can be progressed more effectively, but in other ways.
Thank you, Minister. I'll now go to Colin Smith to wind up and press or withdraw his amendment.
Welfare and wildlife offences is a significant issue, and it's obviously one that this committee agreed needed be addressed as part of the consideration of this bill. It's not clear to me from the Minister's comments as to whether or not the government support an amendment to the bill to ensure that this happens, because it frankly hasn't so far, and I'd be deeply concerned if we didn't have an amendment to the bill that gave the requirement for better sharing of information some legal underpinning. I'm happy not to move the amendment at this stage, or to press the amendment at this stage, but a very clear view that I do intend to bring forward an amendment in stage 3, and I hope the government will be happy to work with me on the wording of that amendment. I don't think we can simply leave this to discussions. I think this does need to be given a very clear direction of Parliament to make sure that the improvements, the desperately needed improvements in information sharing do happen, and that's why I think it does need to be in this bill. We do have another opportunity at stage 3. I don't agree with a number of the points the Minister made around some of the wording of the amendment. It's been very carefully considered, and obviously any tweaks could happen at stage 3 if the amendment was moved, but in the spirit of I think the discussion so far, I won't move or press the amendment at this stage, and I hope that the government will work with me on an appropriate wording for stage 3. Thank you, Convener.
So can I just check that you are going to withdraw the amendment, Colin? Can you say that again, please?
Yeah, sorry, withdraw the amendment, Convener. Yeah.
Thank you. Right, are members content and in agreement that that amendment be withdrawn? We are in agreement, and you'll be very pleased to know that we've come to the point where we can have a short break. We're going to pause for 10 minutes and then resume after 10 minutes. Thank you, colleagues. Now that we've resumed and everyone's back in place, I will call Amendment 99. I'll just give Maurice Golden a chance to hit his seat. Colleagues, just hang on just a minute. There we are. Okay, so I call Amendment 99 in the name of Maurice Golden, which has already been debated with Amendment 67, and I ask Maurice Golden to move or not move.
On the basis that I look for the intention behind this amendment, I'm happy to not move.
Thank you. So that amendment is not moved. Is my colleagues in the committee content? No, I don't have to do that. Okay. Sorry, I'm overdoing things. So thank you. It's not moved. Right, move on. Call Amendment 2 in the name of Mark Ruskell in a group on its own, and I call on Mark Ruskell to move and speak to Amendment 2. Mark.
Thanks, Convener. I'm happy to move Amendment 2. And I would hope that it's clear to most members on the committee and the Minister that we've yet to put in place the right resource to successfully detect and prosecute wildlife crime, especially in our most remote areas. Special constables were found to not be the solution when they were piloted in the Cairngorms, and there is a glaring need for a team of professionals who can work to assist the police in both evidence gathering and enforcement. The SSPCA are that team working successfully in most areas of animal welfare enforcement. But as we heard in evidence at stage 1, there is a mismatch in their powers. An SSPCA inspector, for example, can visit an illegal trap with a live bird inside it, gather evidence and intervene. But when it comes to a trap just 2 meters away with a dead bird inside it, they have no jurisdiction at all. So I'm aware that the Minister knows this needs to be fixed and soon. And I'm aware that governments work with stakeholders, including the SSPCA, to discuss the extension of powers that are needed. However, I am concerned that despite the consensus on what needs to change, we could be waiting a long time before the opportunity for primary legislation comes back round again. 2006 was the last time we had primary legislation able to fix this, and we can't wait another 14 years while our bird of prey populations continue to be decimated. So that's why I'm moving this amendment to allow ministers to act through the affirmative process when the time is right, to confer further powers on wildlife inspectors through regulation. This would enable Parliament to move at pace, but with proper scrutiny in place. The offer from the SSPCA to extend their role in wildlife inspection has been on the table for years and years. We need a robust route to make progress on the issue, and that's what I'm proposing today. Thanks.
Thank you, Mark. And no other members have indicated that they wish to speak on this, so I'll go to the Minister.
Thank you, Convener. Mark Ruskell's amendment appears to allow the Scottish Government to make very broad changes to the function of wildlife inspectors through secondary legislation. And I have concerns about that because, as it's drafted, it doesn't place any caveats or limitations on what those powers could be, and it's not clear why they would be needed or what they're for. And I appreciate that the committee has raised concerns previously about the resourcing of wildlife crime and is keen to explore whether it would be possible to extend the powers of the SSPCA inspectors to undertake investigations in this area. And I know that the committee will be aware that the First Minister has given a commitment that we would look at this issue further. And that's why I can also confirm today that I plan to convene a task force later this year to consider this matter in detail. I will write to the committee about this and provide you with more information about the purpose and remit of the group and the timescales that will be working to, and I intend to do that ahead of stage 3. So given that, I think it would be inappropriate to preempt the findings of that task force by doing anything in this bill that could be viewed as paving the way to extend further powers to persons involved in the investigation of wildlife crime without first having a clear view of what those powers could and should be, as well as any potential wider implications from that. And I understand that the Scottish SPCA are happy with the approach that I'm proposing, and therefore that's why I won't be supporting, or I couldn't support the amendment. And I would ask if Mark Ruskell, that rather than pressing it now, if he would be content to withdraw the amendment on that basis and allow the task force the time to complete its work.
Thank you, Minister. I invite Mark Ruskell to wind up and to press to withdraw Amendment 2.
Thanks, Convener. I am tempted to withdraw this amendment. I take on board what the Minister is saying in relation to the task force and the commitment that she's given to write back to the committee about its purpose and about its remit. I've still got a concern, though, about the legislative timescale for this, and that was really the point that I was making in my opening remarks, because we know that the offer from the SSPCA to extend their powers has been on the table for many years, and we've been going around, the houses on this for so long. So I guess what I'd like to see is, if there is feedback coming to this committee about the remit of the task force and its work, I'd like to see a clear indication of a legislative timescale, a legislative approach for this. I take on board the comments the Minister made about the amendment being quite broad, but yes, I need to see more detail around how the government would intend to take on board the conclusions of the task force and actually deliver that into legislation, because otherwise we could just be waiting for years and years and years for the next primary piece of legislation to come through to actually make the change, which I think we all want to see and is logical. So with that, I won't press the amendment. I'll look carefully at the letter that comes through, and hopefully we can have further discussions with the Minister ahead of stage 3, and I'll consider options at that point.
Okay, so just confirm, Mark, that you are withdrawing that amendment.
I'm going to withdraw that amendment, Convener.
Thank you. And do my colleagues in the committee agree with the withdrawal of Amendment 2? We are in agreement. Thank you. Right, I call Amendment 100 in the name of Maurice Golden in a group on its own. I ask Maurice Golden to move and speak to Amendment 100.
Convener. Amendment 100 relates to the requirement to conduct a general review of the provisions of the Act to ensure it is, in overall terms, sufficient to safeguard animal welfare and protect wildlife. Animal welfare should never have to be an endpoint, but must be something that we constantly strive to improve. As such, a review is an opportunity to test and strengthen the Act. In particular, but not exclusion, such a review would be required to consider the inclusion of pet theft as a specific offence, as well as following up on previous statements in Parliament to act against wearable electric shock training aids for dogs. Both these positions have received considerable support both within and out with Parliament, and as such, a serious appraisal of both should be conducted.
And could you move the amendment, please?
I'd like to move the amendment.
Thank you. No other members have asked to speak in this amendment, so I'll go to the Minister.
Thank you, Convener. This amendment calls for Scottish Ministers to conduct a review of the provisions of the Act as soon as is practicable after it receives royal assent, and I'm not able to support it for a number of reasons. Firstly, it would be highly unusual and I think of little value to review an Act so quickly after royal assent, because where reviews happen, it's generally after several years. Undertaking a review so quickly, I think, would be meaningless, because it would be without any time for practical issues associated with the new provisions to arise or for them to be fully considered. And I don't think we can effectively formally review the new provisions, because there won't be that evidence about how they've operated in practice, and we need to have the time to do that. And secondly, this amendment raises the issues of pet theft and electronic training collars, which I know are matters of particular concern to members right across the chamber, just as they are to me too. However, the proposed amendment isn't necessary to deal with them, because these issues are currently being considered and will be able to be pursued through the Scottish Animal Welfare Commission too, which we will be hopefully coming to discuss later on in the committee today. The Scottish Animal Welfare Commission will be able to consider a wide range of specific animal welfare issues concerning companion animals and wildlife, and they can provide the independent expert advice on how these should be prioritised and taken forward. And I hope that we'll get the time to discuss that in more in detail after this debate today. But for now, I'm content that it is the most appropriate forum to take forward the important issues that have been mentioned already. And finally, I just want to reassure you that many of the important improvements that we're bringing forward in this bill have been developed through close and cooperative working relationships with those who are at the front line of enforcing this legislation, and through ongoing consideration of the operation of their powers. And I have absolutely no doubt that that will continue. So I'm comfortable that we wouldn't require a formal review, and that it wouldn't be of value at that particular time.
Thank you, Minister. I will now go back to Maurice Golden to wind up and press or withdraw his Amendment 100.
Thank you, Convener. I respect the Minister's views with regard to this amendment and also appreciate our efforts to improve animal welfare in Scotland. However, I think we've heard for too long in this Parliament warm words, and I believe Amendment 100 helps strengthen animal welfare in Scotland, which is something that I think we all share, and therefore I would like to press the amendment.
Okay, thank you. So the question then is that Amendment 100 be agreed to. Are we all agreed? We are not agreed, so therefore we'll have to go to a vote. So, can I ask those who are for Amendment 100 to please let me know in the chat box, please? And those who are against it, please let me know. So there's no abstentions. Okay, just give me a second. Thank you. Now, results in front of me. So we have votes for 3, total votes against 4. There were no abstentions. I'll just go through the detail of the vote. So against the vote, sorry, for the vote, we had Finlay Carson, Annie Wells, Claudia Beamish, and against 100, Amendment 100, we had Gillian Martin, Angus MacDonald, Stuart Stevenson, and Mark Ruskell. So therefore, Amendment 100 is disagreed to. Right, I now call Amendment 13 in the name of the Minister, grouped with amendments as shown in the groupings, and I ask the Minister to move Amendment 13 and speak to all amendments in the group. Minister.
Thank you, Convener. The next 6 groups of amendments all relate to the new powers for dealing with animals that have been seized for welfare reasons, found in Section 11 of the Bill. And Section 11 of the Bill inserts a number of new provisions in relation to these new powers in the 2006 Act. And the new powers to deal with animals are found in new Section 32A, and related provisions and procedures are found in the new Sections 32B to 32L. Now, this first group of amendments addresses a number of technical issues regarding appeals under Section 32D in relation to decisions to deal with animals made using the new powers. The bill, as introduced, provides that a court may order different relevant steps to those that are originally specified in the notice which is served on the owner prior to exercise of the new powers. And the provisions assume that the step that's taken is the step specified in the notice. However, the court may direct that another step be taken if an appeal is made under Section 32D. So accordingly, Amendment 21 provides that when a court makes an order on appeal, which is in addition to or instead of the original decision, this is to be achieved by varying the notice. This change overcomes the difficulties posed by any steps being ordered in an appeal which were not specified in the notice. And there are also a number of minor and consequential amendments. Amendment 20 qualifies one of the grounds of appeal in Section 34D5 that are available to owners in relation to the proposed exercise of the new powers. so that any error in fact must have materially affected the decision to serve a decision notice or to specify any relevant step in it. And the purpose of this group of amendments is to ensure the new process works correctly. So therefore, I move Amendment 13.
Thank you. No other members have asked to speak on this amendment. The question, therefore, is that Amendment 13 be agreed to. Are we all agreed? We are agreed. I call Amendment 14 in the name of the Minister, already debated with Amendment 13. Ask the Minister to move it formally. I don't think the Minister's microphone was on, so I'll ask the Minister to do that again.
Convener.
Thank you. The question is that Amendment 14 be agreed to. Are we all agreed? We are agreed. Call Amendment 15 in the name of the Minister, grouped with amendments as shown in the groupings. I ask the Minister to move Amendment 15 and speak to all amendments in the group.
Thank you, Convener. These amendments rectify issues regarding the circumstances in which the ability to seek a release order or a disposal order under the existing provisions of the 2006 Act should be reinstated after the decision notice has been served using the new procedure. So specifically, these amendments allow a release order to be sought when a decision notice is served and an application for a release order under existing provisions in the 2006 Act is then made, but ultimately rejected by the court. And the right to seek a release order will be reinstated a year after such a rejection. Other associated amendments are housekeeping measures in sections 32E and 32F and other consequential matters arising from the main amendments described above. And with that, I would move Amendment 15.
Thank you. No other members have indicated they wish to speak on this amendment. So the question is that Amendment 15 be agreed to. Are we all agreed? We are agreed. Call Amendment 16 in the name of the Minister, grouped with Amendments 54, 58 and 62. I ask the Minister to move Amendment 16 and speak to all amendments in the group.
Thank you, Convener. This group of amendments deals with the implications of the receipt of proceeds of sale where animals are sold using the new powers. Amendment 58 has the effect of inserting a new section into the 2006 Act, which provides for what happens to any proceeds of sale arising from the exercise of the new powers. And this amendment provides that any proceeds of sale must be applied to first meet any liability of the owner to pay relevant expenses, and second to meet any liability to pay the compensation amount. The same amendment clarifies that the owner's entitlement to compensation is instead of any entitlement any owner has to any proceeds of the sale of the animal. And this clarification rules out the possibility that the owner would be entitled to the proceeds of sale in addition to the compensation amount provided for under the new procedures. Amendment 62 makes provision in relation to the proceeds of sale in the event that a court orders forfeiture of the compensation amount. And this amendment gives the court the power to make an order as to the disposal of the proceeds of sale. The amendment also confers the power on Scottish ministers to make provision for or in connection with the disposal of such proceeds of sale. So, for example, that power could be used to specify the bodies to which the proceeds of sale could be paid to. This group of amendments includes a clarification that when exercising any of the new powers to deal with animals in Section 32A, the owner has not only the powers, but also the rights that an owner of the animal would have in taking the relevant step. And Amendment 54 clarifies that the definition of relevant expenses, which is found in Section 32H5, also applies to Sections 32HA and 32K. And with that, I move Amendment 16.
Thank you. No other members have indicated they wish to speak on this amendment. So the question is that Amendment 16 be agreed to. Are we all agreed? We are agreed. Call Amendment 17 in the name of the Minister, grouped with amendments as shown in the groupings. I ask the Minister to move Amendment 17 and speak to all amendments in the group.
Thank you, Convener. These are various minor amendments which have little legal effect on the workings of the new process, for dealing with animals that have been taken into possession, and they relate to consistent use of terminology, including the use of the term protected animal throughout the provisions. And with that, again, I would move Amendment 17 in my name.
Thank you. And no one else has indicated they wish to speak on this amendment. The question is that the amendment number 17 be agreed to. Are we all agreed? We are agreed. I call amendments 18 to 41, all in the name of the Minister and all previously debated. I invite the Minister to move amendments 18 to 41 on block.
Moved on block.
Thank you. Does any member object to a single question being put on amendments 18 to 41? No. So the question is that amendments 18 to 41 are agreed to. Are we all agreed? We are agreed. Right, I'll call amendment 42 in the name of the Minister, grouped with amendments 43, 44 and 63, and ask the Minister to move amendment 42. Sorry. Can I just pause for a second just to check with my clerks? So this is, I've got 40, page 40, call amendment 42. Oh no, page 40 is missing. Yeah, okay. Apologies, everyone. I call amendment 42 in the name of the Minister, grouped with amendments 43, 44 and 63. I ask the Minister to move amendment 42 and speak to all amendments in the group. Minister.
Thank you, Convener. These amendments address the particular scenario where, following the service of a decision notice and exercise of the new powers to deal with animals, it's difficult or impossible to serve a compensation notice by the methods of service that are currently provided for in Section 32G. So, for example, it might not be possible to serve a compensation notice when the owner has either moved address following service of the decision notice and they cannot be traced to an alternative address. Amendment 43 provides some flexibility regarding the service of compensation notices by permitting service by any method which is directed by the court. So the authorised person will therefore be able to apply to the court for such a direction where there's difficulty serving the notice by the methods that are specified in Section 32G. The other amendments in this group make related changes to that, including placing a duty on the authorised person to carry out certain investigations before serving a compensation notice. And with that, I move Amendment 42 in my name.
Thank you, Minister. No one is asked to speak to these amendments. The question is that Amendment 42 be agreed. Are we all agreed? We are agreed. Call Amendment 43 in the name of the Minister, already debated with Amendment 42, and ask the Minister to move it formally.
Moved.
The question is that Amendment 43 be agreed to. Are we all agreed? We are agreed. Call Amendment 44 in the name of the Minister, already debated with Amendment 42, and ask the Minister to move it formally.
Moved.
The question is that Amendment 44 be agreed to. Are we all agreed? We are agreed. I call Amendment 45 in the name of the Minister, grouped with amendments as shown in the groupings, and ask the Minister to move Amendment 45 and speak to all amendments in the group. Minister.
Thank you, Convener. These amendments relate to calculation of the compensation amount to which the owner of the animal might be entitled after the exercise of the new powers to deal with animals, and they ensure that compensation is calculated fairly and without giving rise to unintended results where there are multiple events which give rise to compensation. So the bill as introduced calculates compensation in the context of treatment with reference to the decrease in the value of the animal when it was taken into possession and the value of the animal immediately after the treatment. Amendment 47 revises that approach so that the compensation is measured with reference to the decrease in the value of the animal caused by the administration of the treatment. So that change avoids anomalies occurring when multiple compensation notices are served in relation to consecutive treatments. And to avoid double counting, Amendments 48, 52, 53, 55 and 57 revise and reorder the provisions in Section 32H, which specify the sums that are deducted when calculating a compensation award. Amendment 50 provides for the proceeds of sale to be taken into account when valuing the animal for the purpose of calculating compensation. And that ensures that the proceeds of sale will be used as the starting point for calculating compensation in the unlikely situation in which they exceed the market value of the animal. Amendment 60 makes provision for the scenario in which the compensation amount cannot be paid to the owner of the animal. And it also allows an application to be made to the court for an order as to disposal of the compensation in those circumstances. And that ensures that funds do not need to be held indefinitely for the benefit of the owner when they are unclaimed. The other amendments in this group, Amendments 45 to 49 and 49, make technical changes to the compensation provisions in order to avoid unintended inferences about the exercise of calculating compensation. And with that, I move this first group of amendments under amendment number 45 in my name.
Thank you. No one's indicated they wish to speak on this. The question is that Amendment 45 be agreed to. Are we all agreed? We are agreed. I'll call Amendments 46 to 58, all in the name of the Minister and all previously debated, and invite the Minister to move Amendments 46 to 58 en bloc.
Moved en bloc.
Does any member object to a single question being put on Amendments 46 to 58? Nope, no objections. The question then is that Amendments 46 to 58 are agreed to. Are we all agreed? We are agreed. 59. Call Amendment 59 in the name of the Minister in a group on its own. Minister to move and speak to Amendment 59.
Thank you, Convener. Amendment 59 adds 3 categories of person entitled to be heard in an appeal in relation to compensation under new Section 32I. So the bill as introduced was silent as to who, other than the owner, was entitled to be heard in such an appeal. And this amendment ensures that authorised persons and certain inspectors and constables can be heard during the appeal if the owner of the animal makes an appeal regarding the compensation in relation to the animal. And with that, I move Amendment 59.
Thank you. No one else has indicated they wish to speak. So the question is that Amendment 59 be agreed to. Are we all agreed? We are agreed. Call Amendments 60 to 63, all in the name of the Minister and all previously debated, and I invite the Minister to move Amendments 60 to 63 en bloc.
Moved.
Does any member object to a single question being put on these amendments? Nope. The question is that Amendments 60 to 63 are agreed to. Are we all agreed? We are agreed. The question then is that Section 11 be agreed to. Are we all agreed? We are agreed. The question is that Sections 12 to 15 be agreed. Are we all agreed? Call Amendment 64 in the name of the Minister, already debated with Amendment 12.
Thank you, Convener. It's a technical amendment and it modifies the long title of the bill to include a reference to fixed penalty notices in relation to wildlife offences. So I move Amendment 64.
Thank you. The question is that Amendment 64 be agreed to. Are we all agreed? We are agreed. And the question is that the long title be agreed to. Are we all agreed? We are agreed. So that ends stage 2 consideration of the bill. The as amended print of the bill will be available from Wednesday, the 27th of May 2020. I want to thank everyone this morning for their very succinct arguments and for all your cooperation this morning. I'm delighted that we're through all the amendments of stage 2. We're going to have a short break before we move on to agenda item 2. Thank you. Right, welcome back everyone. The second item on our agenda is to take evidence on the draft regulations on the Scottish Animal Welfare Commission. So I'm pleased to welcome back Mary Goujon, the Minister for Rural Affairs and Natural Environment, and the Minister is joined by her officials, with Andrew Vos, the Veterinary Head of Animal Welfare, and Alison Layton, the Lawyer for the Scottish Government. So welcome back everyone. I'm going to move on to some questions for you, Minister, and I will open up just looking at the material that's been sent to us. There's no rule for Parliament in appointing the chair or members, and I would just like to ask the Minister what the reasoning for this is, and whether or not this actually is needed. This level of parliamentary involvement in the Commission.
Thank you, Convener. The 2006 Animal Health and Welfare Act doesn't specify any role for Parliament when it comes to member appointments, and that includes the chair. But I would say that as the Minister responsible, I was directly involved in the recruitment and the appointment of the chair, and those selected to serve as members were independently selected and appointed purely on the basis of their animal welfare expertise and qualifications. And I would say it's not entirely unusual for that to happen. I believe that the Just Transition Commission was set up in a similar fashion.
And in terms of the expertise that's needed, you alluded that's obviously the criteria in which the representatives on the Commission have been chosen. Could you maybe just outline the expertise that's in this Commission, just to give a flavour of who's involved and their expertise, please?
Oh, absolutely, and I would be happy to write to the committee with more information about each of the members that's on the Commission anyway. But I think when we look at the expertise that's needed, and what expertise even may be needed in future if there are specific issues that the Commission is looking at, that'll very much depend on and be dictated by what the Commission's work plan is, and of course vacancies where those arise, because members cannot be appointed for more than 4 years. Now, I think clearly all members would be expected to have a sound knowledge and grasp of animal welfare, but the skills and expertise required may, for example, be in animal welfare law, in wildlife management, in the practical enforcement, veterinary care. And I believe that the membership that we have in the committee, in the Commission, at the moment is broadly covers all of these vitally important areas. And I would just want to add as well that the Commission will be able to co-opt individual experts who aren't members to work on particular issues as part of working groups established for specific projects, for example. So if there is an area that may be missing on the Commission, as I say, we will be able to co-opt that as and when it's needed.
Great. That's so it's a case of it has that flexibility to move with issues as they come up. So that's very reassuring. I'd like to move on to questions. Carry on, Minister.
Oh, no, I was just going to say as well that, obviously because it would be, providing it's approved today, and that covers companion animals, it looks at wild animals as well. So I think it is important that the Commission has that flexibility and they're able to get that differing expertise as and when required.
Thank you. We have a question on the budget from Angus MacDonald. Angus.
just heard that there's no role for Parliament with regard to appointments, and there's no role for Parliament in setting the budget. So I'd like to ask the Minister, should there be, and if not, why not?
Minister.
Receive and won't be receiving any financial remuneration for their time. So their travel and accommodation expenses that are attributed to the work of the Commission will be reimbursed in line with the current Scottish Government travel and subsistence policy. But I would emphasise as well that these aren't full-time roles, and it's anticipated that the full Commission would probably meet around 3 times a year, and most of the work being done would be done via email and in smaller working groups on specific topics between their full meetings. So that means that the cost associated with the running of the Commission isn't expected to be great. And the Animal Health and Welfare Division have allocated and hold a budget that will cover those expenses and the cost of publishing reports. And Secretariat support is also being provided by Scottish Government officials in animal welfare, so there won't be any direct cost to the Commission for that. So therefore, there isn't really any particular role for the Parliament in setting the budget for the Commission.
Okay, so there's no money set aside at all, is it, or is it a minimal budget? Can you give us a rough idea? No.
Oh yeah, to cover those sorts of expenses, there is some money set aside to be able to deal with that. So the Animal Health and Welfare Division have allocated a budget of around £50,000 to cover members' expenses, as well as the publication of papers. And if the regulations are approved today and the Commission come into being, then once it's been operational for a year, I think we'd be looking to review that budget and revise it accordingly. But this is on the basis of the budget that's been allocated to the equivalent UK Animal Welfare Committee, which was formerly known as the Farm Animal Welfare Committee. And I think based on what we've seen the operating costs for that, we think that appears to be a realistic budget, but minus the daily rate that's paid to members on the equivalent body. But as I say, once it's been in operation, we will of course be keeping that under review.
Okay, thank you.
And just to check, Claudia Beamish, did you have any questions on parliamentary accountability that you would like to put to the Minister?
Convener, those have actually been answered, and I did have concerns as some other commissions, such as the Land Commission, have had parliamentary accountability. But I do understand the distinction because that was set up through legislation. And no, I don't have questions at the moment, and I wish the Commission well on this very significant, important work. Thank you.
Thank you, Claudia. Right, in terms of the overall duty of the Commission, Finlay Carson has some questions to put to the Minister.
Thank you, Convener. Good morning again, Minister. The instrument sets out the functions of the Commission, and it's to provide advice on any matters concerning welfare. It doesn't impose any duty on the Commission to seek to further animal welfare, which is in comparison to the Scottish Commission for Human Rights, which has a general duty to promote human rights in primary legislation. Is it possible for you to give a background as to why no duty is required or appropriate?
Well, essentially, I would just want to reassure the committee that part of the Commission's remit will be the furtherance of both companion and wildlife welfare in Scotland. And so while it may not be explicitly stated in legislation, I have absolutely no doubt that the promotion of animal welfare will be implicit in everything that the Commission does. And the Commission does have sufficient flexibility to provide advice on a range of matters concerning the welfare of animals. So I really just would want to reassure the committee on that point.
Perhaps we need, unlike again the human rights legislation, why is it not actually stated in the legislation?
I mean, again, I would just come back to the point that it's not specifically stated in the legislation within the 2006 Act, but while it's not there, it doesn't mean that that's the Commission wouldn't be undertaking that work. I mean, it's not explicitly stated, but that would be, and I think everybody would expect that to be one of the core pieces of work that the Commission would look to undertake, and actually a core value that they would look to implement in the work that they do. So I do see that as being vital to their role, actually, as I imagine a lot of people would expect of an Animal Welfare Commission. And I do think that, the furtherance of companion and wildlife welfare in Scotland will be a core component of the work that they do and that they take forward.
Thank you. We now move on to questions from Mark Ruskell.
Now, I wanted to ask about the work programme, Minister, and about what is on the work programme for the Commission at this point. And there's a sense that, having just got through stage 2 of the Animals Bill, there are a number of issues that have been parked, really. So, performance animals beyond animals in travelling circuses, particularly greyhound racing. There's concern about the lack of neutering of cats and the positive role that could play in terms of restoring wildcat populations in Scotland. There's also ongoing work that's happening in the European Union around the definition of animal sentience. And then there's also, issues around seal welfare, culling, which I know you're looking to bring in the scope of the bill that we've just been discussing this morning at stage 3. But I'm just wondering, those are some of the issues that sprung to mind, but I'm just wondering, what are your priorities for the Commission to work on, or is it actually for the Commission to set its own priorities and reflect on, what government has worked on and what's still to do?
I think it will be a bit of a mixture there, because as you mentioned, we've just gone through stage 2 of the bill today. There were a couple of issues that I mentioned in that we would perhaps look to the Animal Welfare Commission to look at further. So that I think that one of those areas that we discussed was about Maurice Golden's amendment, where he talked about electronic training collars. So obviously that's an issue that we'd had the guidance, we committed to undertake a review of that, which we're doing at the moment as well. But that's potentially an issue that we could look to put to the Animal Welfare Commission for their consideration. So I think it really, the Commission themselves will be able to, I believe that they'll be looking at their work plan at the moment. So there will be the flexibility there for them to look at issues they feel are important that they should be considering, to potentially see if there's any legislative changes or non-legislative issues that we need to be looking at. But we'll also have the ability to, if there are pressing issues that we feel need their expert and independent consideration, then we will be able to refer those issues to them as well. So I think there will be that flexibility there. And also to add that the regulations will require that the Commission for them to prepare an annual work plan, and that will have to be published as well as an annual report that will be laid before the Scottish Parliament, setting out how it's delivered on that work plan as well. So there will be those opportunities there for the Parliament to be updated on the work that the Commission's undertaking.
So you mentioned shock collars.
Mark, carry on. We can hear you.
Sorry. Yeah. So, Minister, you mentioned shock collars as being like a priority for the Commission from your perspective. But what are the other priorities? I mentioned several there. Performance animals, neutering of cats, animal sentience. What are your views on those priorities, and are there other priorities that you're going to ask the Commission to look at?
Yes, I mean they're very likely will be, because as you'll know, within my portfolio there are a whole host of issues, but it is a case of, obviously we've got to prioritise which issues we would want to refer to the Animal Welfare Commission, which ones could be pressing to us in relation to if there's particular legislation we're looking at, or particular areas where we feel that we need their advice. So it is a case of prioritising that, and the Commission themselves, of course, will have to prioritise their own workload within that too. So it will just be a case of trying to make sure that we get that right, and we are giving them the issues to consider which need their consideration.
So what are your priorities?
I can't give you a definitive list of the priorities that I'd be looking to give to the Animal Welfare Commission at the moment. I mean, but I would be happy to update members on particular issues of interest. And as I say, it will be up to the Commission. They will be publishing, they will be preparing an annual work plan that will be published, as well as that annual report as well, where we'll see the whole remit of that information. But as to a definitive list of that today, I'm just not able to provide that to the committee.
Right, thank you, Minister. Just a question from me in terms of cooperation with other bodies, and I think you've alluded to how the Commission is going to work with others. But I mean, how will the Commission work with other bodies like the Animal and Plant Health Agency as it goes along?
I would imagine that they would work very closely with other organisations, because I think I talked about before what used to be the Farm Animal Welfare Committee, the UK Animal Welfare Committee now, which looks at obviously the welfare of farm animals. So I think that there will be a close working relationship with them, and I know that the Commission are keen to foster a close working relationship with bodies such as that, and making sure they share that knowledge, as well as, but it's not just about the sharing of knowledge, it's about the sharing, ensuring that the resources are best utilised to make sure that there's no duplication of work there. So there's also other bodies such as APHA and similar bodies too that they'll undoubtedly be engaging with, because there is a lot of crossover there and a lot of similarities in terms of the issues that they would be dealing with.
Thank you. Now, no other members have indicated that they wish to ask any other questions. I'll just give you a couple of seconds to correct me if I'm wrong in the chat box, but it's not looking like there's anybody who wants to ask anything else. So I want to thank the Minister and our officials for that evidence. We're going to move on to the next agenda item, which is to invite the Minister to move motion S5M 21671 that the Environment, Climate Change and Land Reform Committee recommends that the Scottish Animal Welfare Commission Regulations 2020 be approved. I can invite the Minister to speak to and move the motion.
Moved.
Now, we do not have any other comments from committee members, so I'm going to put the question on the motion. The question is that motion S5M 21671 in the name of Fergus Ewing be approved. Are we all agreed? We are agreed. Right, so the S is agreed. Okay, so I want to thank the Minister for her time this morning. The committee will report its decision on the regulations in due course, and can I ask members just to confirm that they're happy to delegate authority to me to sign off on the report? We'll all agree on that. Thank you very much. Right, that concludes the committee's business today. I want to thank everyone for their professionalism and time this morning. The next meeting of the committee is anticipated to take place on the 2nd of June. So I close this meeting. Thank you, everyone.